Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. If you're ever in Minnesota and you run into any trouble, please look me up and I would be glad to help or find someone who can help you if I can't. Today we have a special event that I am extremely excited for. If you do not know, please reference the document on the screen, which I will remove in a moment. But that document is the Trademark and Appeal Board's decision to, in favor of Dick's opposition for the trademark dispute. Therefore, Maddox is not the sole owner of the biggest problem in the universe, trademark, and that is great news. And as a special guest to help us walk through this decision and a whole bunch of other stuff today, we have Stephen Burch, who is Dick's attorney, and I'm going to bring him on the stream right now. So if you want to go ahead and unmute your mic there, Stephen, let me bring you to the front and go away. There we go. There we are. So, hey, man, welcome to it.
Hey, thank you. Thank you for having me on.
Yeah, this is this is great. So this is you'll have to forgive me, this is my first interview of this sort since, probably middle school, like some sort of stupid journalism project. So we're gonna kind of muddy through it, but here we go. So yeah, so right below Stephen, if you'll notice, you guys watching on stream, we have Maddox's subscriber count right below him. So we'll see if he loses any subs in real time. And if he does, that should be a note to irresponsibly drink whatever you're drinking tonight. Stephen, I hear you have a glass of whiskey. You want to tell them what you're drinking?
Oh, I'm drinking a Powers John Lane Reserve release. So,
and that is an Irish whiskey.
It is. And it's, just got back from Ireland. That was the best part. There were lots of great things about Ireland,
but the whiskey
was definitely my favorite part.
I need to get over to the UK and do just a straight whiskey tour. So I'm starting tonight with some White and Mackay, and then I will be moving on to something else in just a little bit. But this will get me going. And whoa, that was loud. I apologize for that. Okay. So we do have some ground rules to cover. We're going to get to some Q&A in just a little bit. There are a couple super chats. Oh, hey, Maddox has lost 3 subs. Oh, that's depressing. There are a couple super chats. Anna Ing asked me to start early, which I was unable to do. I was watching a bunch of children. Lady Rackets is now home and is in charge of that. So thank you very much to her. Lucifer Love Monkey says Iron Maiden. Thanks, buddy. Keck7Go says, hi, Stephen, good job, and thank you for helping our dear friend Maddox. Please remember to shill your business and Patreon because Rackets won't. Also, what is the drink of choice for you tonight, which you just covered? And Jeff M says Maddox lost because his trademark effing sucks. Kevin Flesher says Maddox is Sofa King We Todd Did. I don't know what kind of code language that is. But, who knows? So we do have a couple of ground rules here, guys. And this is for the chat specifically. We will be taking lots of questions. I'm going to start off with some interview questions for Mr. Burch, and we'll get to know him a little bit. And then we will take questions from the super chat. And then at the end, like always, once we get through kind of the main portion of it, if you have any other questions and you don't want to super chat for whatever reason, that is fine. Please go ahead and tag me, and we will do questions as long as Mr. Burch will allow us to bother him. So, but one question: no lawsuit questions for Mr. Burch, please. We don't want any appearance of any impropriety. He has acted as Dick's counsel in the trademark matter, and so we don't want any appearance of impropriety. So he's not going to give any opinions on the lawsuit because we don't want anything that he says to have any sort of impact on ongoing cases. So please respect that and keep your questions for him for the trademark stuff. If there are any questions for the lawsuit that you have for me, I'd be happy to field them. So just let me know, and we'll take care of those. All right, so I'm gonna take a sip of this whiskey real quick. And then let's get on with it, sir. So you are Stephen Burch. You are a trademark attorney, and that is pretty much the extent of most people's knowledge about you so far. So tell us about, I guess, first of all, where do you practice law currently?
Right now, I practice law in Melbourne, Florida. We've got a couple offices throughout the state of Florida, Melbourne, Tallahassee, but our practice is regulatory, commercial issues, and we practice throughout the entire state. So sure. Anything, if you're dealing against the government in some sort of regulatory capacity, we handle it.
Awesome. My kind of dude, because no one needs to be dealing with the government in any sort of capacity.
Exactly. We're not as cool as the criminal attorneys, but we represent corporations against the government.
Sure. So how long have you been practicing law?
Since 2011.
Awesome. And have you always done sort of trademark and regulatory stuff, or what? I guess what's your specialty specifically?
It's intellectual property and the other big area we practice is healthcare law, and trademarks just kind of was something I came into. It's kind of what led me into becoming an attorney was intellectual property law.
Okay, sounds good. So you mentioned to me prior to the stream starting that you used to have a different profession. Can you talk about what that was and then how that led you into being a lawyer?
Yeah, I was a software engineer. We did a lot of Department of Defense work. It was a lot of fun, but it was kind of at the peak of the internet. You know, it started taking off, and there was a lot of copyright, trademark, patent issues.
Sure.
And I got really excited about that, and went to law school, and somehow I left an engineering job to do this. And I'm enjoying every second of it, though. It's been a lot of fun.
That's cool. And I'm glad, because personally, I respect the heck out of people who can do software engineering, but and I had tried to do it as an undergrad. I was like, oh yeah, I'll take some programming classes, and quickly found out that I could not tie nooses fast enough to kill myself. So going from there to trademark law is pretty cool. And then so you started off kind of with an interest in intellectual property, and then you I guess joined up with a firm that does this current stuff. Or have you been with the same firm the whole time, or did you bounce around?
I had my own firm for a little bit, but just through a long series of coincidences, I met the owners of this firm, and shortly after I graduated, and I've been working with them ever since, and it's been great. And I don't know, I got really lucky with the firm I hooked up with, who have a lot of work, a lot of really interesting work, and also have a lot of ability to help me, pursue the interests that I want, and help me grow that as well. So
sounds good. Do you want to discuss what law firm you work for and kind of plug it, so that if anybody, there are a lot of people out there who will watch this who may have issues with trademark or regulatory. Lots of business owners and stuff watch the channel. So if you want to certainly mention them and plug yourself, please do. And we'll do this at the end again too, but.
Oh, I'm sure they'd love that. It's Smith Law, Smith and Associates. It's Smith Law TLH in Florida. So if you ever have any questions, please feel free to give me an email, give me a call, and we can discuss it.
Absolutely. And I'll throw a link up to their website, which I'll get from you when we're all done. I'll throw the link in the description. Okay. So if anyone's watching, they can check it out. We certainly want to promote the law practices of people who come on the show, obviously. Mainly mine, but yours also.
Well, I was about to say, that's what I thought this was about.
Yeah. Okay, so you're a trademark attorney and trademark regulatory, healthcare, all that stuff. You're in Florida. How did you get wrapped up in this trademark suit?
I mean, I'm a huge Dick fan, dickhead, whatever the right terminology is. And it came up that Maddox was, he had a trademark application out for the biggest problem. And I remember just being very concerned. I mean, you've got someone attempting to take someone else's property. Conversion, I guess, would be
sure.
the word of the day.
Right.
And then I was just really worried. In my area of law, we see a lot of people abuse intellectual property so that they can use it to their advantage. A lot of attorneys, a lot of judges, a lot of corporations, they're not familiar with intellectual property, and they take it, and you have trademark bullies, patent trolls, and there's a number of terms they use for the different types, and I could just see Maddox attempting to use a federally registered trademark against it. And so, but I reached out to Dick, and we decided to go ahead and oppose the trademark.
Sounds good. We've got a question from the super chat that is pertinent to you. Can trademark law bros practice anywhere in the U.S.? That's from Dominic Peluso.
That is correct. That's one of the things. The U.S. Patent and Trademark Office. It's not an actual court. It's a administrative agency, administrative tribunal. So you can practice if you're an attorney registered in any state, you can practice in front of the trademark board.
Sure. So are you also a member of the patent bar?
I am not. There's extra work that needs to be done, and I haven't had a chance to do it. I should. It would be smart, but
maybe.
I've got enough.
Maybe.
Yeah.
Those patent guys, I'm not sure about them.
They're a little off, if you ask me.
They're definitely the nerds of the legal community.
Exactly. I like to push them when I see them in the nerd.
Shove them in a locker, right?
Yeah.
Okay, so what was your undergraduate degree in, if I may ask? That's a question from my moderator, who I should have asked it earlier, but I'm bad at this. So
no, nothing fancy. It was information technology, information systems. It wasn't like a computer science degree or anything.
Sure. Does the IT degree qualify you for the patent bar? Because I know you have to have an undergraduate degree.
You have to have an engineering degree.
Yeah, some sort of science.
Correct. A computer science degree, which is where I was headed down. I had, getting to like personal stuff, but
sure.
Had some kids at an early age, mid college, and so I'm missing, for the patent bar, I'm missing physics 2 and chemistry 2.
Okay.
And if you were to ask me to do that again, I may have to. I don't think I could pick up again at physics 2 if
man, that would be
15
rough.
years later. I barely remember algebra when I help my kids with their homework. I don't think I could get back into calculus. So.
And yeah, plus when you go through law school, I don't know if the fans out there know this, but when you go through law school, they rip the math section out of your brain. It's just gone.
100%.
And
no, the only thing I know, I know the difference between 30% and 33 1/3% for my contingency fees.
Right.
That's it. That's the only math I know.
Okay, so we've got another question. Denise E. says, Mr. Burch, this is a comment, basically. Mr. Burch, thank you for your services in kicking Maddox's butt. And then Lucifer Love Monkey says, what is Burch's favorite Iron Maiden album, and why is it Peace of Mind?
Hey, you don't have to call me Mr. Burch. Stephen works.
I'm just reading the
It's
chat.
Peace of Mind because that's the only one I know. So that's my answers.
Sounds good. That's a good reason. That's a good reason.
Right?
So drop the chat, and I don't want to make... Okay, Tess, listen. It took a lot of terrible lawyer technological inferiority to get the setup on screen that we have. I'm not going to try and modify it on the fly. It'll ruin everything. Okay, so let's get back, and I apologize for the the schizophrenia of this. But
I love watching your stream or your YouTube station. So I'm just glad to be a part of it.
So you have, so you were concerned about Maddox getting a federal trademark and then using that to bully Dick. Can you give some examples of what trademark bullying kind of looks like, or stuff that you've seen maybe?
Trying to think of some famous examples. Monster Cable is a good one to look at.
Those guys suck.
To 100%. And you get this presumption. You have this. If you're a trademark attorney, you know how little examination goes into getting a registered trademark. It's not a lot. I mean, but no one else does, and they use that, and they just go out, and next thing you know, there's restaurants with the name Monster in them, and they're sending out legal notices saying we're going to sue you if you don't change your name, and you've got these mom and pop businesses just caving. I mean, a personal experience. You should look up Trader Joe's. Trader Joe's does the same thing. I've had a personal client, abandon a trademark because, the cost of going up against, a large corporation and the cost of intellectual property litigation is not worth, the benefits. And so that once you have that registration, you can start pushing it against people, and it's a big deal. And I think I said this, but a lot of attorneys don't have any sort of intellectual property background, and that includes judges. And you get judges, state court judges especially, but even federal court judges who know nothing about trademarks and who give a lot of deference, more deference than they should to a registration. And it's bad.
Now, correct me if I'm wrong, but at least the patent, there's a specific appeals court, a circuit for patents alone. Does that include trademarks as well?
It's a separate one, but yes, so in fact, the opposition was in front of the Trademark Trial and Appeals Board.
Oh, okay.
And then both patents and trademarks. There's the federal circuit. So, you have your 11th Circuit, 9th Circuit, whatever.
Right. But
there's the federal circuit, and all patent claims end up, and a lot of trademark claims, all the appeals from the USPTO, the Patent and Trademark Office, end up at the federal circuit.
Sure. My understanding, this is what I've heard, so correct me if I'm wrong, but the district court decisions on intellectual property have the highest overturn rate once they get to that appeals process of anything else. Is that correct? Yeah,
it is. And some of that has to do with, and depending on your position, this is either bad or good, but the federal circuit is very pro-patent.
Sure.
There's an undercurrent of people who have issues with the current patent regime, including the Supreme Court, by the way. The Supreme Court has, consistently done, and the federal circuit has done its best to limit and read in as much as they can to every Supreme Court opinion to uphold patents. So every time you get a district court saying, this patent's not valid, you get the federal circuit. You get to go to the federal circuit and say, maybe it is. I look at the Google case, the Google versus Oracle, and they've done everything in their power to uphold, pro intellectual property. I don't know how much you followed that, but it's an interesting case. The federal circuit said, no, maybe you need to remand and let a jury determine fair use.
Sure.
And they did. The jury said, oh yeah, Google's definitely falls within fair use. Goes back up to the federal circuit, and just recently the federal the jury was wrong. That's not fair use. So it's
we really want to hear the jury's opinion. No, never mind. We don't want to hear the jury's opinion at all.
Yeah, we wanted to hear it. We just didn't care.
Okay, so you said you watch my channel. Have you seen? I did a video on a Domino's issue with a guy named Sam Crack. He's another YouTuber, and
no.
Okay, so
I saw it in the updates. I've only seen most of what I've seen has been Dick Show related. Although
sure.
I did see some Google stuff. So
yep, when you get a minute, I mean, you can give my video a watch or whatever. But basically, this YouTube guy named Sam Crack, he restores automobiles, and he went out and he found salvage a Domino's DXP delivery car, which were the specialized Domino's car. They've got the Domino's sort of red, white, and blue on the hood, and they've got the Domino sticking off the top like a dumb thing. And then they've got, on the side of the car, they've got a pizza warming oven that's presumably powered by the battery of the car, so they could deliver pizzas warm. So he buys this car on salvage for like $800, and then someone from Domino's, and it's not clear if he was contacted by Domino's corporate or by a franchise holder. If it's a franchise holder, then I think the claim is nonsense. But assuming he was contacted by Domino's corporate, they said that he's infringing on their trademark, and he needs to remove all of the Domino's iconography, including the oven from the car. So I'm guessing from your giggle, you fall about where I fall on this case. But what do you think about that?
It's ridiculous on a lot of levels. But it goes back to the trademark bullying issue. Who wants to fight Domino's? I mean, right. You're clearly right. But at the end of the day, you're fighting over a gimmicky car you had that you bought at auction. But how do you, no reasonable consumer is going to look at that and have a likelihood of consumer confusion with Domino's. That good, huh? You like it?
This is good. I was going to talk about this. This was given to me by Brett from Fargo. This is North Dakota Select Club whiskey. It's tangy, which is a little weird. I was kind of confused. It is labeled as a Canadian whiskey, and as I read that, it also says I'm sorry. So, but this is. I mean, it's good. It's got. It's very smooth, but it's got a little tang going down rather than a sweetness to it, which is a little different. Mike P from the chat asks, "Do I need to trademark my band's name?" Do you want to talk about trademarking bands' names and iconography a bit?
So, normally I don't like to get pedantic about stuff, but using a mark in commerce means that you have a trademark on it. It's called a common law mark. If you start using your mark in interstate commerce, which is a very easy threshold, by the way, as an attorney, you've probably gone through the whole constitutional issues of where the federal government has powers, but it's nice to have a federally registered trademark for your name. It allows you to, it gives you a lot of power over stopping people from starting a band. So say you're in California and you have a band and you're selling your music throughout the country, but your main presence is in California. You start to get some traction, and meanwhile, somebody in North Carolina shows up and they start using their mark. If you have a federally registered mark, you could stop them. Without that, you're kind of stuck on a state-by-state basis. Who started using it first in that state? Where did your common law mark expand to? The federal mark kind of eliminates that issue. It says, I registered on this date. This is mine from here on out for these services or goods. Sure. So I would recommend it if it's something you plan on continuing. I mean, it's a business decision. It costs money. It's something you've got to maintain, update. But if it's a real business venture and it's something you're interested in, protecting your band is important.
Yeah. So what kind of cost goes into registering a trademark? Assuming there's no, like, obviously with Dick and Maddox, there is contention over the ownership of the mark. But let's say I create a band and they've got, some kind of unique name. What's it cost me to register a mark?
Taking out attorney's fees, but the actual registration is only approximately $225 per class of goods.
Sure.
So it's not a massive cost. I do recommend getting an attorney. Some people like Maddox didn't, and their registration suffered a lot of issues. And I will tell you that the registration process is deceptively simple. It's an online form. If you want to go and fill out the online form, anyone can do it. It's the research beforehand to let you know, are there going to be issues? What's the examiner going to say? Are there potential opposers? Those are the kind of things you pay an attorney for. But
right.
The actual registration is not that much.
Sure. Yeah. So my understanding, and I do not do trademark. I've hopefully made that very clear. But my understanding is that you have to, when you hire an attorney, part of the service that you get is basically they're going to go out and they're going to look for those potential conflicts. So they're going to search the trademark database, see if there's anything that even comes close to kind of infringing or that you might be infringing upon. And then they would advise you, like, let's say there's something close, but you guys are in completely different industries. Then typically my understanding is, if there's no chance of consumer confusion, you can still get your mark. Like if you're a band and you're going up against a bakery in the middle of like Illinois, you're a band in California, you're probably not going to run into too many trademark issues unless the bakery's like super famous or something. Like Collins Street Bakery in Texas, for example, is a very famous nationally recognized bakery. That would be a problem. But if you're naming your band Collins Street Bakery, you've got a problem. But outside of that sort of issue, that's part of what a trademark attorney kind of brings to the table. Can you elaborate on what else they do outside of that? If you've just again, if you're coming to it like I've got a band or some other brand name, like let's say I want to trademark Rekieta Law in my logo, and there's no one out there obvious. There actually is another Rekieta attorney, my cousin, but she doesn't practice. But there's no other Rekieta Law brand that I'm aware of. So what sort of other services would a trademark attorney bring to that?
Well, I mean, that's the big thing. Is the most important thing is there going to be a likely consumer confusion with an existing brand? Because one of the things you don't want to do is file a trademark registration and catch the eye of and these bigger brands, these bigger companies have people who watch the register. You don't want to catch the eye of someone who already has that mark, because then what you're going to do, you've now put on the record that I'm using this mark, I'm using it in commerce, and if someone else already has that mark, they're already using that mark, you've done 90% of that attorney's job in some sort of trademark infringement lawsuit, and you're setting yourself up to lose everything you have. And that's the biggest thing we do, is just kind of set you up and say, well, what's your mark? What are you using it for? What are the odds that, when we go to register this, you're going to be okay, and that it's going to be a successful registration. You're not going to have issues. You're not going to have oppositions, and it's just that research. So that's the biggest thing with registering trademark. On the other end, I mean, the litigation side is more of the fun part, but the important part as a business owner is making sure your brand and your mark is protected, it's safe, and it's not infringing on someone else. And if it is, that you're not advertising to the world that it's infringing on someone else.
Right. So there was a super chat, but it was retracted because it was in regards to the lawsuit. And I'll read you the question, but do not answer. It was just because I want to make sure that we respect people who do the super chats for sure. And I'll answer the question, but it's been retracted, so I don't have the exact text, but it was something along the lines of, what was your opinion of the Heather S. admissions? And I will say that the Heather S. admissions are extremely damaging to the lawsuit. They may be extremely damaging to Kevin Landau, and I hope they are, because my personal opinion is that Kevin Landau knew from the start the details of the Heather S. emails, and he attempted to obscure it from the court in the way he wrote it. So I hope he gets sanctioned out of his flipping mind for that. But you don't have to say that. I'll say that.
Yeah. Thank you.
And then Daniel Warren says, is the biggest problem trademark effectively dead / at a standstill, or can one party sell it to the other? Thanks for everything you've done. And that's a good question.
Yeah, I think our argument from the beginning, and it's the argument that won, is that the trademark is still active. It's still in use, and it's owned by a joint venture that both Dick and Maddox own. It's a valid, ongoing trademark, and to the extent that one person owns it, it's certainly transferable to someone else. Intellectual property, like any other property, can be transferred, can be, it can be given, it can be acquired under any sort of legal means.
Sure. So there's another super chat, and I'm a little confused about this. So I'm going to ask it's from Greedav. He says, did Lori Foster's loose lips sink Maddox's ship? And I'm not entirely sure what Lori Foster said that he's talking about, and I don't know if it's related to the lawsuit or the trademark. So Greedav, if you don't have to super chat again, but if you want to just tag me.
Actually, no. I get what I do,
okay.
And I will take it. It never even got. I'll take a win all day under any circumstances. A win is the best thing in the world.
Right.
But we had lots of arguments for our trademark suit, and we never had to address them because we set forth our case in our motion for summary judgment, and Maddox decided, after asking for an extension, to not respond. And by not responding per the rules, he's conceded all of our arguments.
So
so none of her issues matter for this.
So I didn't cover this, but the rule you're referring to is it's referenced in the document. So I want to go through that real quick. It's 2.127A of the trademark rules. And that rule, I'll summarize the relevant section just because it's kind of a long rule and it covers a lot of stuff, because the trademark court is a ramshackle thing, apparently. But
it is.
The basic
government tribunals.
Yeah. The basic gist of it is that if you fail to respond to a motion, the court can take it in a couple ways. They have kind of the option to take it in a couple ways. And one of those ways is if you fail to respond, they can decide that it's a concession. They don't have to decide it's a concession from my understanding and my read of the rule, but I'm not a trademark attorney, so you're welcome to chime in on that. But it seems like they have the option to take it as a concession, which they did in this case, or they have the option to take it on the filed motion. So if they want to take it on the filed motion, they find out that it's legally deficient. In theory, the non-opposing or the non-responding party could still win. Is that correct? Or is it, in your experience, that if you don't file, you're done?
I mean, in general, if you don't file, if you don't care enough to file, the board has enough things to do. I've never seen anything where they would take the time out of their day to do something. Maybe in a pro se type situation, they would care more. But no, if you don't have the time to respond, especially after having the time to ask for an extension of time to respond, they're going to treat it as conceded. And there's no better win to me than that. I know some people wanted like more of an. As an attorney, I was very happy with very short. Everything you said is right. Conceded. Over.
Right.
That's the best kind of win for me.
You look at it that way, but have you seen the movie Bloodsport with Jean-Claude Van Damme?
I have seen the movie.
Remember when he's got Chong Li's head and he's like cranking on his neck and he makes him say Mate? That's how I look at it, because I think that's how Maddox would look at it in the inverse. So Maddox, in my opinion, he said Mate. He tapped out and quit.
Well, if it makes anyone feel any better, there was I don't know if you're you may be familiar with the terms of claim preclusion,
right?
And issue preclusion.
Yep.
It was a big deal. a Supreme Court case in 2015, fairly new, legal term-wise, about the importance of USP TTAB decisions. And the Supreme Court, over the objections of Scalia and Thomas, said issue preclusions applies to trademark claims. And so if in a federal court or in many state courts, if the issue of was there a joint venture ever comes up again, there's a very, very strong claim that that issue's been decided. There's been an administrative tribunal. You don't get to argue that again. That was the main point of our motion for summary judgment, is that there was a joint venture. It was owned by both people. And so now, to the extent that some people are benefiting off of, SoundCloud, anything from the joint venture, that issue is precluded from being argued again in front of a court. At least there's a strong argument that it is.
Right.
So it's not as. Oh, go ahead.
I was going to say, what the heck was Scalia and Thomas's problem with that?
The obvious thing is they don't. Administrative agents telling us what to do? No.
Sure.
That's not their thing. So.
Yeah, that's kind
of.
But
for us,
that sounds like Scalia for sure. Sorry, go ahead. You said, but for you.
Oh no, I was saying for us, it's great. It's not binding on state courts, and it's a fairly new decision, so I don't know how it will hold up in different courts under different factual arguments. But there's a very good argument that there's no way Maddox gets to now claim in any court proceeding that there was no joint venture.
Sure.
It's there. He had a chance. He failed. He lost.
So what I've been telling people, and feel free to correct me on this, but I believe I'm correct. So it's not that Dick and Maddox technically co-own the mark, but they co-own a joint venture which has sole ownership of the mark. And that joint venture is presumed to be a general partnership with 50% ownership. Since there's no operating agreement, there's basically very little sort of rules about what they can do about that. Is that so in essence, Maddox can act as an officer and owner of the mark, so he could market stuff in the name of the biggest problem in the universe, and Dick could also market stuff in the name of biggest problem in the universe. The only hitch would be if they make any money from that venture, it would have to be split between the two of them. Is that roughly correct?
I'm not a California attorney, so there may be details, but yes, that's the general gist of what we argued. Is it's not that they both own this mark, it's that they owned a business, and that business owned a mark, and somebody doesn't get to just, one owner of the business doesn't just get to take off and run with it because they feel like it.
Sure. So acknowledging that you're not a California attorney, but assuming this were in the state of Florida, for example. So if they make money from the mark, they have to split it. What if one incurs expenses on behalf of the mark? Do they have? This is a question that came up, I think, on the IRC. Someone basically said, what if Dick did something that incurred expenses on behalf of the biggest problem in the universe? Would those expenses be split, or is that one of those issues where it becomes practically more money to enforce than it does to than would be any sort of benefit from it?
In Florida, I think if you're a partner and you have, income or expenses, they're split. Whether it's worth it to enforce depends on, your how much fun you get out of enforcing things.
Right.
But to be fair, things cut both ways. So you want to be careful about where you really want to start a lawsuit over.
Sure. But in theory, let's say Maddox is spiteful about losing this mark And now he says, you know what? I'm going to start a biggest problem in the universe tour, and it's going to cost, we're going to go venue to venue, and it's going to cost me $60,000, and then I'm going to sue Dick for that $30,000. What does that look like for his 50%?
That looks like he's going to have a hard time. I mean,
I would think so too.
Speak about any business. I mean, you can't just have a partner going off and making decisions and then binding you to them. Especially one of the issues we had with the trademark is there's nothing in writing, and so you have a business, but you've got someone trying to bind a non registered party. It's not like there's an LLC member registered with the state that you're, there's no way that you're going to get someone who has no part of the contract, who is opposed to your issues to pay for that. I mean, who knows? You've talked about lots of frivolous things on this on your YouTube station. So I mean, who knows? But that would be another among the frivolous things if it happened.
I'm just trying to get into the mind of an insane Armenian. That's all I'm trying to do. Okay, so Gats has done a super chat. He asks, can you help trademark the Landwy pack, fetching lawyers who tear your opposition up? No chase rough enough to flee. These are all puns. I don't know if you can see it. Anything is possible with our bark. Thanks, Gats, for that.
I will tell you. You pay the SPTO fee. I've got the stuff on pro bono for that.
Okay, so Adam Atticus Angel asks, will the documents that were previously marked confidential now be released, or are they forever in limbo? And that's a weird one, because I noticed that on the decision, it's reduced to a mere footnote that says that the point is now moot. But I don't know if the mootness of it means that it's since the victory of the mark that they're not confidential, or because of the mootness, they are still confidential. So can you comment on that?
My first comment is going to be, that's a tricky answer. It's going to be up to Dick and his decisions. My thoughts on whether those documents are confidential is they're not. We filed it. They're not confidential. They've never been confidential. To the extent that Dick wants to release them, that's up to him. However, I will say this on Dick's end, there's a standard protective order in place for every trademark lawsuit. What's the cost benefit to releasing things that may open yourself up to litigation? I will tell you, I've read them. I've written a motion regarding their confidentiality. I've seen them. They're not confidential. They don't fall under the standard protective order. To the extent Maddox thinks they do and his counsel thinks they do, I believe they're wholly incorrect.
Right.
So unfortunately, I asked the board to review this and give us a definitive answer. They didn't. So now we're kind of stuck to what do people want to do? And
now now I don't mean to call out anything on this, but there was a filing.
You can. I know what you're going to talk about.
There was a filing of the documents where it looked like there was an attempt at redaction, but maybe due to some sort of software issue, they didn't redact
software
properly.
User. There was an issue.
Is that the extent of the confidential documents, or is there another set of documents that is confidential, or that was marked confidential in addition to those?
So there was a set of allegedly confidential interrogatories that were necessary to support our motion for summary judgment. Due to user error, they may have been uploaded without the redactions being applied.
Right.
Due to people, I've never in my life had people notice things so fast. The clerk fixed them the next day, but there were people within minutes noticing our error. Thank you.
Sorry.
I know. But in addition to that, I mean, that's just the answers. If you read our motion for in-camera inspection, there's also a set of requests for production documents that came in that they also months later claimed were confidential.
Right. Yeah.
And those were never accidentally uploaded.
Okay. So and the ones that I read, again, not knowing the specific trademark rules very beyond just a cursory read, but just going by the federal rules of evidence, I mean, I didn't see anything in there that even qualified as a business exemption or any sort of, I mean, there's nothing. All of it.
It's laughable.
We're talking about interrogatories. Like those are, by default, they're public unless there's something specifically confidential inside them, which would be.
It was.
I mean,
I'm not I'm not like Greenberger. I'm not as clever as some attorneys.
I don't know if anybody is as clever as that guy.
No one is. It's impressive. But the caption to the case takes up a whole page. And that was confidential. And I'm like, how is that confidential? The entire thing was utterly ridiculous. It was embarrassing. And I don't know how the other attorney was able to, with a straight face, submit some of the things he did.
Yeah, that's weird because from my read of the motions and the actual writings of the trademark case, I found Lawson to be relatively, I mean, he didn't appear to be incompetent. He appeared to be competent, but the defense of those particular issues was really strange, that he would defend the confidentiality. I mean, I guess you have to, right? If your client demands it, you kind of have to do it. But what I can't get around is, I know the conversations I have with eccentric clients, we'll say, and I wish I could be present for every conversation that Maddox has had with his attorneys, because even, I'm going to give Landau the benefit of the doubt. I have to think that he listens to some of what Maddox says and says, buddy, that's ridiculous. Like, at some point, but maybe not. But Lawson especially, because I did a quick Google search on Lawson. They seem like a boutique firm that does pretty much only patent trademark issues, and I assume they're pretty good at it.
Yeah.
I mean, there's nothing to tell me otherwise. They look relatively professional. And like I said, the writing of their documents was fine. But I have to imagine, like, wait, who are you is part of that first question.
I've had some odd clients, but I couldn't imagine submitting the interrogatory answers he did. That had to hurt. I wouldn't have wanted to have done it.
Yeah. So, okay. So here's a weird question. If you don't want to stretch into this, please just shut it down right away. But let's say there's a certain YouTube attorney who happens to have access to those unredacted documents, and he happens to release them. Do you see any sort of issues with that? Assuming they were legally acquired, they were not acquired by from Dick Masterson in any sort of way. What my understanding would be, it would fall, and if you'll probably have to think back to law school for this one, but there's basically a press exception for acquiring documents that would otherwise be confidential. Is that,
if you've acquired them through legal means, then you have. I think about confidential documents, documents that like reporters find that have to do with top secret information.
Right.
That's perfectly protected by the First Amendment. I couldn't imagine how obtained anything through any sort of legal means would have any issue with producing them.
Because I may have previewed those documents on a previous video, but
I imagined a lot of people did. There's nothing worse than having your mistakes broadcast within minutes. It's humbling.
I plan on maybe doing a follow-up video going through them in detail, but we'll see. We'll see about that. Gatscat says he has a he's quoting, I think, Maddox. He says, "I know what I'm doing. I have a good brain." So, and he also reminded me that I already previewed the documents, which I did, but I didn't go through all of them yet. And,
you did. I watched that. And I appreciate it. Thank you. At least at the time. I don't care what you do now, but at least at the time, I was like, thank God.
But, sorry. Uh-oh. Lagavulin police are going to come after me for drinking too much. Because I'm starting to get laughy here.
Do they not understand their brand and their market? That's I'll help you with that. That seems ridiculous.
Yeah. I don't know what their issue is, but it's funny to me. I never expected a sponsorship because I do a random Lawsplaining channel with like 3,000 subscribers, which I am much, much appreciative of every single one of them. But the idea that Lagavulin or any major whiskey brand would sponsor someone with less than 100,000 or 200,000 subscribers was silly to me in the first place. That's what made it great. That's what made it fun for me. But okay, so I had a theory question for you, and hopefully you'll indulge me in this. But under what theory does Maddox get to file a motion to get this order vacated? And the only thing I could think of was that maybe Dick hired like Russians to kidnap Lawson and make him miss the deadline. But is there something other than some sort of weird corruption on Dick's part that gets a second look at this thing?
Ah, man, it's hard. I will tell you, I mean, I could come up with dumb things, but it's really bad when you request an extension of time, you get granted that extension of time, and you do nothing when that deadline comes. You don't get to argue, oh, I didn't know that was the deadline, when that's the deadline you asked for. It's really hard to come back and say, oh, there was a clerical error.
Right. And especially like if he had filed on the 16th of March, maybe, right? Maybe.
Right.
There was a clerical error. The internet went out. My house was hit by a hurricane, something on the West Coast, which would be really weird. But
no, there was the first day when I'm like, and because he's West Coast, and so I remember staying up really late thinking, because he's been notorious for filing like at the last minute.
Sure.
And so I remember I stayed up and I was like, this is going to happen, and nothing. And I'm like, well, maybe it'll be the next day. Maybe he had the day off. And then, nope. After a while, there's no excuse that, I mean, this is essentially a federal court is going to accept when you've done nothing for, I mean, it's been weeks, if not a month. I don't know what you argue. I mean, the only argument you have is, I don't know what conversation Maddox has had with his attorney, but maybe you have an attorney conversation with your malpractice attorney, but it's nothing that's going to persuade the federal circuit, let alone the board of the Trademark Trauma Appeal Board.
And he has, from what my understanding is, Lawson has a partner. So even if he were to claim like I had a stroke and I was in the hospital, his partner at that point should have taken over and done the filing. Is that correct? Have you ever seen anything weird like that? I mean, I haven't.
No, I've never experienced anything. I mean, to me, the answer is he didn't want to respond. They had some sort of conversation. Lawson knew it was time to respond. He's not, as you said, there's nothing about him that made me think he was some sort of, like the other attorneys we're used to dealing with. He's not like that. So he knew there was a deadline, and he chose not to respond. And there's no other explanation.
Yeah, I was thinking either. Now I don't know how it works in trademark court, But I was thinking maybe Maddox ran out of money and didn't pay Lawson. But I think it's more complicated than that, because at least in my criminal defense stuff, and typically in my civil stuff as well, if the client were to run out of money and I couldn't just not respond, I would have to ask the court for leave to withdraw. So my thoughts on this, and you can fill in kind of the trademark experience, but is if Maddox ran out of money, he had a conversation with Lawson. Lawson said, well, I can file for withdrawal if you want to pursue this, but if you just don't have any money, maybe it's time to let it go and focus your money elsewhere. Any thoughts on that sort of scenario that you want to share?
Yeah, I will say that the trial, the TTAB it's not a court, and so it has very, very limited powers. It can approve or deny, and a few things in between, a trademark registration. It can't sanction a party. It can't sanction an attorney. It doesn't have the powers that a court has. I wouldn't imagine that if Lawson were in front of a federal court, he would have just not responded. But because it's the TTAB and because it has that limited amount of power, it may not be worth it to try to withdraw. It may not be worth it to go through that sort of process, because I've withdrawn from clients before, and it usually involves filing a motion, which involves drafting a motion, and sometimes you have to have it heard, and so maybe you just didn't decide to go through that. The TTAB doesn't have the power that your normal court, your state, federal courts have. So,
man, I'm in the wrong court.
well, yeah, you can't screw up. You do
right.
Willy-nilly over here.
Yeah, you just make it up as you go. That's fine. Which
pretty much,
in all honesty, that's
say it confidently.
That's how I run most of my practice, anyway.
Right. It's all attorneys do. You say things very confidently and hope no one notices.
It's funny because that's a jest, but it's also the truth. Like,
very much.
Inside baseball for you chat fans and everybody watching right now is in law school, they prepare you for literally zero of this.
Nothing.
And you have to just decide kind of how to do things, or you have to latch on to a firm early on that teaches you how to do things. My personal experience, none of the firms in my town, which is about the size of this room, was hiring. And so it was, well, I can't move because of family reasons. We're here, and I'm right. Perfectly fine with that. But we're here, so it's like I can't move. So if I don't have a job with one of these guys, then I have a job with me. And so I threw out the sign, rented a place, and that's Rekieta Law, and that's where it is. And now I'm so glad that I did that personally, just because I am terrible at taking direction from anyone else. That doesn't fly. I'm no longer good at having people tell me what to do. But yeah, you have to learn everything on the fly.
Everything.
All you learn how to do is research with Westlaw or Lexis.
Yeah, it's nothing useful. There's nothing useful that you learn in.
And you can learn Lexis and Westlaw in respectively an hour each, and that's about all you need. But
and if you'll pay them money, they'll teach you. They just up all the time. Just please, for the love of God, switch.
But yeah, that was my biggest issue getting out of law school. I went to my first appearance for a criminal trial, right? And the judge looks at me and she says, all right, so this is the first appearance. Do you want the charges read? And I'm like, no. I'm very confident, right? No, I don't want the charges read. It's like, okay, how do you plead? Well, we don't want to issue a plea or enter a plea at this time. Okay, so should we schedule this for omnibus? And my eyes got about 8 miles wide because I had never heard omnibus used in the context of a criminal trial at that point. And it turns out that, and then she's like, well, that's a Rule 11 hearing. And I'm like, oh, buddy, I got nothing on the rules. And she just kind of nods at me. I'm like, yes, we'll take the omnibus. And I very
That's
quickly,
the way to go.
Yep, I very quickly went straight to the criminal rules in Minnesota and read them thoroughly the next morning. But yeah, go ahead.
But the scary thing is, you learn something. You're like, okay, I've got that. That'll never happen again. And then at the next hearing, something new, and it never stops. Like every time you go to a hearing, there's something you have to kind of BS your way through.
Yep.
Like, oh,
yep.
Definitely.
Oh man, I have a criminal hearing. I have 3 defendants from the same set of facts right now, and the prosecutor just did me wrong. They wanted a Rule 17 hearing, and I'm like, you know what? You're gonna have to refresh me on what Rule 17 is, and it's a hearing where the court has to ask all of the defendants and make sure that they know that I'm representing everybody. I'm like, well, yeah, they're literally all in my office, and that there's no conflict, which in this case there obviously isn't. That the defense is not he did it, so we're fine. But I'm like sitting there in chambers with the judge, and they're like, yeah, we're gonna have a Rule 17 hearing. I'm like, oh my god, what are you even talking about? And the Rafter says, imagine unironically going to law school. The Rafter is also a prosecutor in one of the fair states. So he's my natural born enemy, but he's far enough away.
I was about to say, so he works for the government. And
right. He's
let him on your feed.
He's a status pig, but we'll forgive him for that. Garrett Snyder says Alphabet of Law Schoolness coming out 2019. Okay, so this is an off the wall question for you, and that you will not see coming, and it is not asking you to currently comment on the lawsuit. But let's say an enterprising group of attorneys who are all fans of the Dick Show decided to write a specific book about the trademark, the lawsuit, the whole dramatic saga from a legal perspective. Would you be interested in writing something along the lines of, say, your law school writing project, which mine was 30,000 words on Fourth Amendment protections in the digital age. But would you be interested in doing a chapter of that book?
Oh, anytime. I'd love to. It's funny, you start at undergrad, and you get these page limits, and you're like, oh, I can't make it to the 20 pages. And by the end of law school, all of a sudden that upper limit, now as an attorney, it's like I only have 35 pages to write. I'd love to write a chapter about anything, man.
Well, good. There may be a lawyer on this stream in contact with you about that as plans develop. But, I don't know if you know this, but Dick Show fans have charted 3 times now on Billboard.
I do know.
And I think the next place to conquer for the fan group is the New York Times bestseller list. That's just my personal opinion. So.
Out of spite, I'm for that.
Okay, so let's go back, way back to the beginning of the stream. Someone asked a question, and I didn't ask you at the time, but I'm going to ask you now. So you mentioned that you listened to The Biggest Problem. You were a fan of that show. Were you a Maddox fan? What brought you to The Biggest Problem? Like, how'd you get there? And then what happened during the breakup for you emotionally? Like, let's get deep.
Very deep. It's funny. So, I told you I was a programmer. And Maddox was just kind of the thing that went around, and, read the Maddox webpage every now and then, and he'd have his updates, and he'd make fun of, and I don't know, I thought they were funny. I bet if I went back, they'd probably still be funny. But it wasn't the most important thing to me. But I remember going back and checking at some point, and there was a link to the Biggest Problem, and I started listening to it, and I enjoyed it. And I just had life things going on, and it's funny thinking back as you hear about all the other stuff that happened, but I just kind of fell out of it. I'm like, it just doesn't, it's not as fun anymore. So I stopped listening to it. And I finally went back to check on it, and it's like, oh, it's canceled, but Dick has his own show. And that's kind of where I ended up. He's definitely the more entertaining. As I started listening to The Biggest Problem, Dick was definitely the more entertaining of the two. I mean, it wasn't even close from the beginning. So,
yeah, what did it for you? For me, I'll lead off this question for you. What did it for me? I started listening as a fan of Maddox. Never heard of Dick before in my life. And I think I'm in a similar boat. I can't remember exactly how I heard about this podcast, but I think I was in a similar boat where like I just randomly checked the Maddox webpage thinking, oh my gosh, what was that webpage that I used to read when I was in like high school? And I checked it out, and there was a podcast, and I was like, oh good. Let's listen to this. And I listened to the first couple episodes, and Dick was kind of a meathead at first, but it became apparent pretty quick that like he might be playing a role here as a meathead, and I quickly realized that he actually knew stuff, was able to construct good arguments, and I became a fan of him almost from the get-go of listening. And then what buried Maddox for me was his anytime he talked about economics, starting with that broken window fallacy.
That was the worst.
Dude, I was screaming in my car. Oh my gosh. Like I'm like yelling at the stereo as if that would make it go back through to them. Oh, oof. So what did it for you?
I don't know if there's any one thing, but when I was an engineer and now as an attorney, I'm usually the dumbest person in the room. Like I've been crazy privileged to work with crazy smart people, and you just get to know, and as you listen to the show, you could kind of tell Maddox was a dumb person playing the act of a smart person, and Dick was a smart person playing the act of like you said, a meathead, and you could just tell, like, he was funnier, he was smarter. It was just way more entertaining to me to listen to Dick. And now that, more things have come out, it's just embarrassing that I fell for any of the Maddox stuff. But it's...
I get mad at excuse me. I get mad at my high school self. I'm like, how dare you have been duped?
Right?
But
I have a copy still. It's in a box now because I've moved, but I have a copy of Alphabet of Manliness in my house somewhere, and I'm like, that's embarrassing.
No, I mean, I got one right here.
There you go. Yep.
And I'm actually not embarrassed by owning this, aside from, especially since he disavowed it, because it's no longer his book. But before I was a lawyer, I worked at at Thrivent Financial, which is a financial institution based in Wisconsin and also in Minneapolis. And I worked downtown, and on my lunch breaks, because I was an enterprising not worker. I would take my lunch break, and I would spend the entire time doing anything other than eating. And then on my way back to the office, I would get food and then eat at my desk, because my job was literally reduced. You mentioned software engineering. We had a back office system that resembled strongly at the time MS-DOS, and so it was literally nice. I reduced my entire job to a series of keystrokes. And I never touched my mouse, and everybody around me used the mouse like idiots. And I was like, come on, guys. It's so much faster if you just memorize how many tabs you do between hitting A. But
100%.
I would go through, but I went to Borders bookstore, which I think they're out of business now. And on on their discount rack, they had the Alphabet of Manliness, and I picked it up and I looked at the picture and I was like, oh, this is funny. A guy punching a gorilla. And I picked it up and read the forward and I was like, oh, I'm buying this immediately. I still think it's hilarious. And it's a shame that he doesn't think so anymore, because it's probably the culmination of his career and I would say the peak. And after that is him falling off of Mount Everest for the rest of his life.
Right. Although I will say, you know, I don't want to, again, you know, I have limited things to talk about, but, you know, I've been on both sides of representing winning, losing, and you get people who are clearly wrong. They're going to lose. You know they're going to lose.
Right.
And you would think that they know they're going to lose. And yet, you know, I don't know who said this, but someone smarter than me, it was, you know, everyone's the hero of their own story.
Right.
And there are people who, as everyone else in the world sees it, they're losing, they still think they're the hero. And they still think they're doing what's right. And I don't think there's very many people, including Maddox. And it's funny to see the comments, but I don't think anything's going through his head other than I'm winning and or the world's biased against me. And it's, yeah.
I mean, I think that's dead on, because I can't imagine. This is what worries me about the whole scenario, and you don't have to comment on this. I'm going to just kind of expound on it a little bit, but it worries me about the Landau situation, because based on some statements that I've heard, one, Maddox said that the $20 million idea was Landau's idea and stuff like that. I think that I'm sure you've met them. There are some attorneys out there who capitalize on people believing they're the hero of their own story. Personally,
Right.
I'm the worst marketer in history. Like, when people are sitting in my office across my desk, they'll tell me, you know, their situation. I'll say, literally, don't hire me. Hire some other person with experience in this issue. And they do it anyway, which is rude of them, but I appreciate it. But there are attorneys who go the opposite way, and I think it just looks like maybe there was some predation on the part of, and I, again, not knowing what has actually been said, it's just kind of the way things worked out. I cannot imagine that that the way the lawsuit has unfolded, that it got there on the advice of a level-headed, competent counsel saying, look, $20 million is the right idea. Because in my opinion, maybe Maddox had a claim, maybe in California, maybe for $30,000 to $50,000, maybe somewhere in there. And if he had done something like that, I think it would have looked, at least appeared like a reasonable case. I mean, the way it broke down, either Maddox is so insane that all this made sense, or he's been had and duped by a professional duper. And again, you don't have to comment on that. I'm not gonna. That's my personal opinion. But
my only comment to that is, I think, as an attorney, you know, you have an ethical obligation to your clients to be realistic. I mean, there's one thing I will represent to the public. I will represent anything about my clients. I mean, it's my duty. Zealously represent my clients. But internally, I have a duty to tell my clients, no, you know, we're not doing this. This isn't happening. And if it is, it's happening with another attorney. Because you're wrong, you're off. I have no legal or factual basis to make this. And if I do, I'll make it. But at some point, Maddox has met an attorney who maybe didn't tell him what I think an attorney who is doing what an attorney should do would have told him. Because there are lots of things, including specifically this trademark opposition. I mean, I wouldn't have opposed it. There's, especially if the opposition was going to be what it was. Right. So,
yeah, and I think I think the saving grace for Lawson in this situation is that Maddox had already filed, and now he says, now it's being opposed, and he's like, well, I've got to defend this because I think I own it. And Lawson's like, well, I mean, you know, I can imagine the conversation went something along the lines of, look, you've got a thin claim. We can maybe say that you own it based on the ownership of, or based on the use of the font that you typically use, based on the phraseology that you typically use. And we can say that, you know, based on these things, that it was understood that you own the mark, and that's where it went. But man, this is going to be thin, and I can't promise you anything even close to a victory. I mean, we might have a chance, but it's a prayer.
I will never fault an attorney defending. Like he had to defend, and I have a hard time faulting an attorney for defending any position. I mean,
right.
That's your job.
Yep.
He may have wanted a bigger retainer. I don't know, but you can't fault a guy for defending a position. I've defended bad positions because that's what you're stuck with. But there's a difference between defending a position and offensively asserting a position, I guess.
Right.
That's the extent of my response to your original comment, I guess.
Sure. We got a couple chats here. Gats asks, or he says, today's events bring the score for the best lawsuit in the universe to 1-0. Not that it's a contest. And then we have a new one from Kellen Steck who says, this is a question. Stephen, did you have an unrelated party message you directly on social media or email about the copyright suit while it was active? Did you have any unrelated party message you directly on social media or email about the copyright suit while it was active? So I'm guessing he's asking if anybody who was following the conversation sent you any messages outside of being either Maddox's attorney or someone representing Dick.
The only message I got, and this was kind of funny because it got me.
Hold on. Can you repeat that? Because you cut out like right while you were saying it. Sorry.
Oh, it's okay. The only message I received, and it got me, was a prank message from Kevin Landau, and I'm glad that because I read it, at a stoplight on my way to work, and it was instinct, and it was the apostrophes were misplaced in the appropriate ways, and I thought it was him, and I almost forwarded it to Dick, saying, "Holy crap, he's after us here too." But I waited, and when I read the whole thing, I'm like, "Oh, somebody!" And they almost got me. But that's the only one prank message is the only thing I got throughout the entire thing.
That's shocking, frankly.
I was surprised. Yeah.
So Tillip asks, "What's your favorite Death Grips album?"
Hey, you're out. Sorry, I could lie to you, but
how dare you? Not
I know.
My Death Grips.
I'm just a poor country lawyer. I can tell you my favorite Hank singer, but no Death Grips.
Okay, so let's see. Okay, so I have a question for you. So the Dick community obviously is a very dynamic thing. You know this, and your client Dick is very dynamic. Have you had any? So the attorney's dream is a client who has no contact with the outside world and will never say a word ever. Was it a challenge to represent someone who has a giant platform, who's going to talk? Like, my guess is there's no stopping Dick from talking about what he's going to talk about. Was there any sort of challenge with that? And have you had anything similar outside of the Dick show that you've ever represented where it was a similar case where you've got an outspoken sort of person?
To the first question, I think I told you I'm lucky to work for the firm I work for. Like we don't shy away from anything.
That's awesome. That's fantastic.
So it is. It's very lucky. And so I had no problems from the beginning. I'm not going to tell you what I talked about with Dick, but for the most part, I had no problems. I knew from the beginning I'm not going to represent a guy who makes his money online talking about things to say, hey, don't talk about stuff. I mean, hey, I think that's your job as an attorney to work around. I mean, there are exceptions to that, but for the most part, you expect that he's going to say stuff. In terms of other clients, God, yeah. We represent right now. I mean, we represent a nursing home who's being accused of killing 12 people in the wake of Hurricane Irma. Only 12.
A nursing home that's only accused of killing 12 people?
Yeah.
I accuse them of killing people all day. No, I'm just kidding. Go ahead.
Yeah. No, but I mean, we take on high-profile clients, and they say things, and things comes out in the media, and it's your job. I think as an attorney, you want to, on one hand, you want to control everything. I mean, it's your nature, let's reduce risk. But I think the other part as an attorney is to say, here's my client, let's handle what they have and deal with it. It's not your job to change the client. It's your job to represent them. And I mean, absent, some very specific stuff, if your client wants to talk about things, you need to figure out how to work around. I mean, but you're a criminal attorney too, so I mean, understand. Yeah. I'm in a different world than you are.
My clients, I'm like, you shut your mouth, you go into hiding. I don't want to see you ever again outside of scheduled times. If I see you in public, I'll kill you myself.
Right. We have a different set of rules, but I think, but we also represent corporate clients, and they have an image to maintain, and winning a lawsuit but not having a business at the end, well, then what did you win?
Right.
And so they have competing interests, and I think it's part of our job to manage the overall best interests of the clients. So
right,
we deal with it, and it's fun. I mean, it's fun to, on one hand, it's nerve-wracking to have some guy, across the country pointing out spelling errors in your pleading. But on the other hand, it's what you do, because it's good that they're getting the publicity. It's good that their issues are out there. So
I try and be fair, because it's easy as a third party to read, like, to everybody watching. It's really easy as a third party to read these documents, find a little mistake, because especially when it's broadcast to the world and I'm reading literally every word, it's easy to find a missed of or an and or something like that. And I hope that everybody watching gives full deference to attorneys for having to write these, like, I don't know, I guess I'll talk about it from my perspective, but when I have to write motions to suppress evidence, and they're 10, 15 pages long, and we're attacking literally everything. Like, you get to a point where you're in robo mode typing this out because you've got a deadline, and sometimes you're going to miss something, you're going to misspell something. And that's, obviously, even every attorney in the lawsuit so far has had some minor error in their stuff. There's one attorney who stands out amongst the crowd as the pinnacle of making countless mistakes, to the point where I'm not sure if they're mistakes anymore. But I almost wonder, actually, if that guy is trolling me at this point. Because
his signature is still the apostrophe's wrong on counsel for plaintiffs. Still, at this point, it's
Okay, so Jason Benham says, Booze Allen. I don't know what that is. If you could, you don't have to super chat again, but if you tag me and explain your super chat comment, I might be able to respond. I'm not sure what Booze Allen means. Although that does remind me that my glass is empty. And I'm going to switch personally to some gin. because I was given this gin by a fan, and I'm a big fan of it. This Heyman's gin. Do you drink gin?
I do. I like gin with a little bit of vermouth and maybe an olive, and I'll drink it all night long.
So I read a chart on the internet, which means it's true, that if you drink gin, 100%. You hate other people, but not yourself. You have a high regard for yourself, but hate other people. So
that seems correct.
Oh, okay. So Adam D asks, since the partnership is clearly terminated and Mark rejected, can we all create YouTube videos as the biggest problem in the universe? My personal input, I don't think the partnership is clearly terminated in any sort of sense. And you can go ahead and follow up with that if you want to.
Yeah, I would argue that the biggest thing from the board's order is that the partnership is not. I think the most important thing that anyone should take away from is that Dick owns, and there is a joint venture currently outstanding that owns the biggest problem in the universe, and it's ongoing. It's there. It's been there. Dick owns half of it, and to the extent you want Dick coming after you for screwing with this stuff, have at it. What is he, the joint venture police? I don't know.
Sounds like you're borrowing language from someone there.
I have no idea what we're talking about.
So to clarify some things for the chat, I guess from a general perspective, withdrawing from a business venture, a joint venture like this involves typically. It doesn't necessarily have to have documentation to get into, but you better have documentation to get out.
100%.
Because otherwise, like let's say, Dick and Maddox had a phone call and discussed ending the joint venture, which by all evidence that we have, they haven't done that. If they even had a phone call about that, and then Dick goes ahead and uses uses the mark for his own ends, and then Maddox comes back and says, wait a minute, I never got out of this. Unless Dick has a recording of that phone call or something weird. I guess weird to me because I don't typically record phone calls, but I know I've had clients who record everything because they don't trust the government. Outside of a specific recording, you need to have a documented thing. So I want to be very clear that as far as we know, Dick and Maddox have an ongoing joint venture that's not dissolved in any way by them hating each other. Lots of companies are run by people who hate each other. I represented a husband and wife in a domestic issue. They were about to be ex-husband and ex-wife. It was a domestic violence issue, and they were just buying a bar, so everything was going great. So they were gonna work together after a domestic violence issue and after a divorce. So people
own a bar. Awesome.
Right. This is a good plan. And I wish them all the luck in the world, and I thank them very much for paying me on time. But as far as like, you can own stuff with people you hate, that doesn't dissolve anything. Before either party acts as if they're the sole owner of the mark, they need to have documentation as such. And I don't think that's going to be forthcoming from either of them without some money changing hands. Frankly, that's my personal opinion. Guns Beer Freedom 87 says everyone loves gin, and that chart is 1,000% accurate. So apparently everyone loves gin and simultaneously hates everybody else, which I think is, if the world operates in that way, we're doing something right. Generally,
I agree.
But okay, so you work with a big firm, but you said initially you work.
Oh no, we only have
okay.
It's a small firm. We're lucky to have but it's 1, 2, 3, 4, 5. It's a 6-attorney firm.
Sure.
Yeah. So it's not a solo firm, but it's certainly not a big law firm. It's it's a small firm, which is, I think, has been great because it's given me the ability to attract certain clients while also not stuck doing document review and letting me go out and go out and do arguments and put my face in front of a judge, and it's been fun. But it's not a big firm. I don't want to get that impression.
Okay, so to me, as me being a solo practitioner, everything's a big firm.
True, I understand that too. I get that.
But what I was getting at was, so you okay? Let me rephrase that, Your Honor. Let me rephrase. So you work for a firm that has some sort of resources. You have 6 attorneys. I assume you have paralegals, and you probably have administrative staff as well that handle stuff like billing. But when you were a solo practitioner initially, what kind of issues did you have? Because personally, I love being a solo practitioner, but man, getting people to pay me is like I need a sledgehammer, I think.
I faced, so I was an engineer before, and that has advantages. But the disadvantages, I'm not a people person. I like to, I'm good with arguing in front of judges. I'm okay in front of juries. But I'm not, I don't go out. I can't market myself. So it's nice. I think that is the biggest problem I had. Is there's nothing worse than. I'll tell you a story. My marketing plan to start my firm was I was a software engineer, and this was about the time that apps were a big deal, and the iPhone had apps, and I'm like, this is what I do, and app developers are gonna want help with their intellectual property, with starting corporations. And I was right. A big portion of my business plan was correct. The problem with my business plan was that no one who was starting an app company had any money. Certainly, They didn't have money for attorneys. And so it was poor marketing. I was not good at marketing. I was not good at, to the extent I got clients, they paid okay, but it's hard to develop business clients when you're solo, and especially without any reputation. Once you have a reputation, it's probably easier, I guess.
Right.
But I think that's the biggest thing the working for a firm has bought me is I've got this establishment. And I just suck at marketing. That's not who I am.
Right. We're not built that way in general.
No.
We're good at deconstructing, but constructing is actually kind of difficult for us. At least for me.
100%. And yeah, they tell you to go to these marketing events, and you're there at like 7 a.m. with a coffee trying to talk to some guy who does tile.
Oh, like, tell me, you're talking about Chamber of Commerce right now, aren't you?
100%. You got me. And I'm like, what am I doing? I paid money for this. So, yeah, I'm not a marketing guy.
Yeah, I'm in B&I, which has actually been a pretty good marketing decision because you get to know a specific group of people really well. And in my case, it's all the business owners around town. But to give you some perspective, I'm in a town, my office is in a town of 15,000 people, and no one knows my name because I did not grow up here. My family is not around here.
Yep.
I mean, they're starting to learn it, I suppose, through my legal work. But my entire business is word of mouth. And take your issues with attracting clients without money and also charge them with felonies. That's my practice area. Like, my clients are literally selling drugs to make ends meet. And then the feds kick in. Okay. So because she's been bothering me the whole stream about it, and I have forgotten multiple times, Tesk wants me to ask you about genericide. Genericide. Do you know anything
trademarks?
Yeah, I guess with trademarks, and I think it was in the context of patent and trademark trolls.
So what happens? I mean, you're getting into my fun time. And this is good stuff.
Have fun with it.
Yeah, you take great brands there were great brands like Trampoline or Aspirin, or Xerox was kind of the latest one, but they were able to fight it. And you get these brands that are so great that everyone discusses them and their services through their brand name. And so what happens is you get a great service like Xerox, and instead of saying, hey, I want to make a copy of something, I want to make a Xerox of that. And now I sound old as I'm saying that, but
no, but this is the Kleenex of the world, right?
The Kleenex, it is. And next thing you know, all of a sudden, if your mark becomes generic, you could have the greatest mark in the world, the greatest brand in the world, and it's worth nothing. Nothing at all. And you can't enforce it. You can't do anything with it. And Aspirin is a great example. Trampoline is a great example of brands that they were a name brand and they let people use their brand, and next thing you know, they have nothing.
Man, I never even considered the fact that Trampoline was a name brand. I figured that was just a noun.
There's some joke about your mom. For the most part, it was a name brand, and they lost it. They lost it through genericism. Trademark law is intellectual property law in general. I think is the most exciting thing in the world, but I realize that not a lot of people do. But if you're a corporation and you have a brand or you have an idea, have some sort of intellectual, creative expression, and you let that go, you do so at your own peril, because it will go away, and people will capitalize on your hard work if they can. I mean, it's a very voltairistic market.
I think it's funny because, like you say, these brands are the brands with the, they did the best job. That's the funniest part, is they did the best job of marketing that can be done, because, my moderator, Tess, she keeps mentioning Velcro, and it's like, yeah, Velcro's great, but no one on earth would have said command strip. Like, I'm going to command strip this thing together. No.
No.
It's like 3M. No, 3M sucks.
But that's the funny part, is they won the marketing aspect on one end, and then they lost it completely. That's why you mentioned Kleenex. If you ever watch a Kleenex commercial, it's Kleenex brand tissue. It's never Kleenex. It's, they do their best to distinguish their name from their product. But man, Velcro, I forgot about that one. That's a great example of someone who they won the battle, but they lost the war.
Okay, so you're in the South. You're in Florida. I grew up as a Texan, and in Texas everything is a Coke, right?
100%.
In Florida, is everything a Coke?
Everything's a Coke, unless you're some Yankee coming down and you may have a pop or a soda, but they're
right.
Distrust. So don't trust those guys.
So is Coke at risk of genericide?
So there's this idea. God, every question, I feel like feel like now, but it's a maybe.
Right. Well, Coke, we're lawyers here. It depends. Right. The answer for everything.
100%.
That's okay.
So trademark law has carved the side now at this point, and it hasn't always been this way, but they've carved aside this exception for famous brands now. So I've had a client who had I forget, God, it's been too long, but they had a Mick something, and nothing to do with McDonald's.
Sure.
But it had Mick in front of it. But because of how famous McDonald's is, they were going to lose. And an element of trademark bullying, an element of just famous brands. But trademark law has adapted and evolved.
Sorry.
No,
I read someone said they used to call it Jumpaline, but then your mom got on one.
Thank you. That was the joke I was thinking of, but then I forgot. I don't act well under pressure.
And the gin makes it funnier. Oh goodness. So yeah, it's funny because, like you said, the typical answer we have to give to just about everybody is it depends, and no one likes that answer. In my experience, no. They all want to hear you win, right? You win,
yeah.
You win and you win big, but usually, at least with my and again, I'm in a small town. We typically are not dealing in high dollar wins, even on the civil matters, unless you're talking about like an insurance paid claim. But other than that, you're not talking about high dollar amounts. But no one likes that answer of it depends. And
oh no,
but it always does, right? Because that's what people don't seem to get, is that no matter how clear the statute sounds or reads, or how clear the decisions are, there's always an argument to be made. And even if the argument is literally everything you've ever mentioned on this is wrong. And I mean, I personally have a case like that right now, that is, thankfully we're in negotiations at this point, but it's a tough one. And it's this weird case where I have a homeowner who's in an association, and we'll say it's a 5-unit condominium, right? But they only did 4 of the units back when they built the thing in like 1982. They never built the 5th one. So we have this weird errant lot next to a unit, and we have an unfinished exterior wall. So it's not a code passing wall. And technically, the homeowners association should do something about it, but they don't own the lot next to it. So they can't build on the other unit without buying the lot or getting the lot owner's permission or the lot owner to buy it. And they don't want to finish the wall, mainly because they're poor as an association. But my client's like, well, why? What am I paying you for? And so we had this weird thing. But then complicating that was the association failed to file their LLC registration, basically, with the state for 20 years. For 20 years, they failed to file. And then, but the state has this dumb law that is worded so poorly that basically you can file at any time and cure the 20-year defect. And it just retroactively reinstates everything. So we went to...
Court is the same.
We went to small claims court and we won. I got the whole thing dismissed in small claims.
Nice.
But the way small claims works in Minnesota is if anybody doesn't like it, they can have the district court vacate the judgment immediately and rehear it. So it's like a pointless endeavor.
But you have to go through it.
Right. So we won at small claims, we got it dismissed, and now we're in district court technically, but we're negotiating it out, which is what should have been done in the first place. Like these parties needed to come to an agreement, and that's what my client has wanted the whole time, is like, just build the freaking wall. Like, cause she can't, right? She can't build the wall because she doesn't own the property line, and she doesn't own the exterior of the building. But it's just stupid because, she comes to me and asks, what do we do here? And it's like, well, it depends. And it's like, you should win. Like, in principle, you should win because all of the stuff points to the answer of this, this is wrong, and this association is responsible for this answer, or for fixing this. But in court, they have a legitimate argument the other way. But man, you should have. I wish I would have recorded and could play the phone call of the other attorney when we got notice of the dismissal, and he called me back, and he's like, I don't understand. I don't know what judge would have. He's like, I don't know how the judge got there. And my answer was, well, I like to think it was my charming argument.
Right? Oh, God. How good a feeling is that?
That's,
yeah.
Oh, go ahead.
If you want to hear my favorite story, there was a case our firm had They had it since before I was an attorney, before 2007. It's this guy. He bought some property. He was going to build a concrete batch plant. He went and he applied for everything, and mid approval process. I live in Florida, so there's a bunch of retirees. Said, no, we don't want a concrete batch plant near our property. So they petitioned the county, and the county removed that as an approved, as a permitted use during his approval process. And that started back in 2007. It was the first thing I worked on when I started at this firm. We took it to trial. The important part was in front of a judge. It was a bench trial for that part. And we lost. We lost to a 78-page judgment as to how wrong we were. Like, point by point, you're stupid. We appealed, and I'm writing this appeal, I've got better things to work on. There's no way you win over a 78-page. We won like a month ago. And there is nothing better than watching the county attorney, like, listening to the appellate judges, like, ask him questions, and you just see him like, well, the trial court said, and there's nothing better than watching your opposing counsel lose after thinking they're so right, and then just watching them being taken down a step. That's why I like being an attorney over an engineer. Winning's great. Watching other people lose, it's amazing.
Yeah. Okay, real quick. Jason Benaim says the stage name Maddox actually comes from an old mech anime. Does he still have trademark protection over that name, or how does that even work?
I mean, I would assume that he has, some sort of intellectual property right over that name. I know nothing about anime, so I'll stay out of that. But
you are the healthiest man on this planet. Good job.
Yeah, but he probably has a right over that. But that said, intellectual property rights are property, just like everything else. And I mean, if you lose judgments, you have to collect against something. So intellectual property, regular property.
Should he sue? Brad Pitt and Angelina Jolie's son Maddox for becoming more famous than him just by being born?
I would think so. I would. I am jealous of that kid already. My parents did nothing.
So someone asked if you miss the creative aspect of engineering. This is a person who is considering going into copyright law, and presumably is an engineer, because they're asking you specifically if you miss the creative aspect of engineering.
Oh, that's to the contrary. I mean, that's the part I love the most about being an attorney. As an engineer, I went in and there were some, problems you had to deal with, but at the end of the day, you knew you were going to solve the issue. I mean, maybe you were tasked with 4 hours and it took 8 or something.
Sure.
I mean, there's nothing more creative than coming in and saying, well, how do I convince a judge that's heard the same argument a million times to think that my argument's different?
Right.
And I don't always succeed, but the times that you do are, oh man, they're so amazing. I am on a high today because I won, and it is the best feeling in the world to win. And yeah. I don't know how to put that. You don't win a lot. You don't lose a lot either, to be fair, right? I mean, you end up in the middle a lot of times, which is disappointing. But
well, not me. I
do get to
literally
win.
always win.
Oh, well,
I'm just kidding.
I know Nick Rekieta. I would love to be at some point as good as you, but
I'm completely kidding.
I'm jealous all day long.
No, I have a very good track record in court, but that's because in criminal cases, when you're about to lose, you just settle and get a better deal than when you're going to lose. But
that's no different than civil.
But
it's.
I wanna put this out to the people watching and anyone who is watching this later or now or whatever. If you're happy about the result of Dick winning this trademark lawsuit, that is a mere toe in the hot tub to what we get to feel when we win a case. I can honestly say that outside of my wedding and the births of my children, that winning lawsuits is the funniest and best feeling on earth, especially when you thought
100%.
Maybe you were going to lose, or like this is kind of an out there argument, and then you win and you get to just smear that in the face of someone else. Like, even if it's like you don't ever call them up and smear their face in it, but in your brain, man, you're just like it's
like I said, winning is one part, but making the other person lose, it feels so good. It's amazing.
Especially when they're just like I had this weird case, and I don't just do criminal law. I do some small civil stuff as well. But I had a case with an eviction, and my opponents, they're like, ooh, I can't disparage them and say they're the worst people on earth, but they're flipping close, right? So they could not actually evict my client because my client didn't do anything to merit eviction. So what they did was they falsified a police report against my client to get a restraining order against them. And when their attorney, I met their attorney for the first time, and he was this guy. And like I walk up to him and he's in a suit, obviously he's in a suit, but because we haven't fixed that system so we can wear shorts and polos yet. But
oh god.
But I walk up to him, he's in a suit, and he's a normal looking guy, and we start talking. And I don't know about you, but when I talk to other attorneys, it feels like a jousting match. Like you start at opposite
100%.
ends, and you're like, yeah, everything's going great. Your client's a dick. And then you go, like, you turn around and you get back to that point over and over, and it's just a nightmare.
100%. Yep.
Yeah. So this guy, like, we're outside of the courtroom. I'm waiting for my client to show up because my client was stuck on a bus in traffic. And I'm like, we're just going back and forth talking about, okay, so here's the situation as we see it. And then this guy's like, consistently jabbing and digging at my client. I'm like, buddy, we're not in front of a judge. Like every 5 seconds, I'm like, we're not in front of a judge. Can we just talk like human beings and try and work this out? And he's like, well, but your client did this. And I'm like, chill out. Like we're not in front of a judge. Oh, it was the most frustrating thing. And winning, man, it was great.
Oh. But I will tell you, I found, again, I don't want to talk about other lawsuits, but I found that attorneys who don't have the ability to say, okay, we're not in front of a judge, we're not in front of the public, we're just talking.
Right.
Those attorneys are not the good attorneys. They're the ones who they make dumb, really brash decisions that they're just angry all the time. And they lose at every point. Oh, and it feels so good when they lose. It's the best feeling.
This dude and I, so they propose a settlement, which is basically like my client could come in and remove their stuff from the property by a specific date. Okay. And we said, okay, that's fine. Cause that's all my client wanted was their stuff. And so it's like, okay, we'll come remove the stuff. And I actually have a giant van because I have so many kids. So I have like a 12-passenger van. And I took the seats out and I went to help my client move because my client has no network of people to help out.
Right.
So I'm like, I'm gonna help my client move, and this is 2 hours away from where I live, so it's taking up my entire day. My client gets there before I do with a police escort, which was part of the order. And the other party calls their attorney, and this idiot advises them not to let my client or the police into the property.
Listen, no, don't ever let the police do anything. I'm on.
I called this guy up. I'm like, what on earth are you doing? And then his client leaves. Like, he's like, nope, you can't come into the property, even though you have a police escort. And this is exactly, oh yeah, my mouse cursor is on Burch, sorry. Even though you have a police escort, and this is exactly what the order says, your client can't come into the property, and neither can the police. And I'm like screaming at this guy on the phone. I'm like, how dare you? Like, you advised your client to defy a court order? Who are you? Like, what attorney on earth would think this is the right course of action? And I mean, you should have seen how I could hear himself I could hear him urinating over the phone. And within 10 minutes of that phone call, he had withdrawn from representation. Like, it was
well, it's always the client. The client's insane. Well, I've got a case. If this is it's one of my favorite cases, watching someone lose. I had a case. I represented a doctor against this healthcare thing. They sued him for allegedly violating a restrictive covenant. They sued him for like $250,000.
Oh my gosh.
We countersued for over $50,000 because they breached the contract. They did stuff. We went to trial. I won. We won. They won nothing. We won our $50,000. The attorney called me up afterwards, and we were discussing. I'm like, what are we going to do? He's like, I'll tell you what. Instead of $250,000, we'll settle this case, even though you won. You pay us $100,000, and we won't appeal. And I'm like, I think we're good. We won the appeal. Now we've got tons of interest. It's amazing how certain clients, they don't listen. And then I will tell you this, you shouldn't, but I blame the attorneys. The attorneys should have something. They should have the balls to tell their clients no. It's
right.
It's kind of a miscarriage of justice to allow certain things to go forward, at least through an attorney. Like, I think that's part of our job.
Yeah, and you have the responsibility to say no, and if yes, not me. Like, honestly,
exactly.
Like, let a Landau take care of it. Not me. Well, man, we're right at coming up on 2 hours here, and we've taken a bunch of time, and I really, really appreciate it. So what I'm gonna do is give a couple minutes to the chat to ask any questions that they want by tagging me, and as the questions dwindle down, we're gonna wrap this thing up, and I'll let you get back to gloating with your family. But if there's any final thoughts you have on the trademark or anything you want to say about that case, feel free to let loose now. Or if you don't want to, if you want to talk about other stuff, I love trading war stories anyway. And I think the viewers really love hearing like just the hilarious and ridiculous stuff that we have to deal with. So you can talk about whatever you want, but when we get to the very end, we're going to make sure and plug your law firm again. And then I'm going to ask you a very important question, and then and get you on video record answering it, so you will not be able to weasel or lawyer your way out of it. Choose your pejorative.
I've never lawyered my way out of it. I don't know.
Okay, so you do not have to answer this if you do not want, because you are a family man, but I'm going to ask it. And if you want to demur, you go ahead. It's is Mr. Burch a tits or an ass man?
Oh, I'm an ass man. 100%. I don't know. Miss Burch is somewhere watching, but she knows.
Okay, so I have a question for you, and this is screw you, chat. I'll get to your questions in a second, but this is personal. How close are you to Legoland?
We are very close to Legoland. I've been to Legoland.
Okay,
and given the age of your kids, it's amazing.
It's next month. I am going to be in Florida at Legoland, and I would love if if we could arrange some sort of time, we get together and share a glass of scotch or something like that. Would you be okay with that?
Hell yeah.
That would be awesome.
Definitely. Oh, I would love to meet you. Yeah, that's amazing.
That is just fortuitous, and I just thought of it now. I'm like, oh, he's in Florida, and obviously, like, this is how my brain goes. Someone's in Florida, they're close to where I'm going. Period. Full stop.
That works for me. It's yeah. But okay, no, we are very close, within an hour and a half of Lego.
Okay, so we will. I will be in contact with you, and we'll make that happen for sure. And I'll send you our full itinerary, because I would love to meet you, and if you're open to it, and you want to have the family around, we could do a dinner or something. But we'll figure that out.
Definitely.
So Samuel Olivero asks, for both of you, how do you guys handle losing a case? And I will answer real quickly. I don't have to deal with this much, because as typically a criminal attorney, like I said before, when we're about to lose a case, we end up taking the state's deal, and that is a better outcome for my client than flat out losing. So I actually don't have much experience losing all out a case, and I will let you roll with that, because you're in a little different practice area.
Have you seen the Ace Ventura, where he's like scrubbing himself off in the shower and just trying to get the stench of that's how I handle losing. It sucks. It's not fun, but it's winning makes up for it. But losing sucks. I won't pretend it doesn't.
And in my personal experience, I don't want to put it out like I never lose because I'm a super attorney. That's not a thing. Okay. Like, any attorney who says that they don't lose is probably lying.
100%.
Or they're a prosecutor, and prosecutors cheat.
Are liars.
Yeah. They are liars also. But, I lose motion hearings from time to time and stuff like that. And it is honestly the worst feeling in the world, because, at least in my experience, I'm baffled. I'm baffled by how on earth the judge came to the conclusion that they came to. Is that it usually just doesn't make any sense to me, because it's like, okay, the Constitution is clear. This person has this protection, this protection, this protection. And honestly, the motions that I've lost amount to the judge saying, but we did find drugs. It's like, well, I know, but everything you did to get to the drugs is against the Fourth Amendment, you dummy.
Right. I will say there's, as I've grown as an attorney, like, losing has been different. Like, there are things I lose, I've lost because I feel like I could have done something different. And those are the hardest.
Right.
There are other times when I lose and I feel like, what the F? I'm trying not to curse on your stream, but I don't know why the judge can't conclusion they came to. And those are a little easier to accept. Those aren't as bad as the ones that keep you up at night thinking, well, maybe if I would have researched more, maybe if I would have studied more, maybe. Those are easier to accept than the ones that I feel are more my fault.
Yeah, and some inside baseball for the fans out there who are watching is, we do try and be extremely thorough in our research, but there comes a time when you're writing a motion where you say, you know what, like, this issue I don't feel, or this case I don't feel like is the right case, and then if you lose, every one of those decisions haunts your dreams, even if they would have made
Forever.
no difference in the case. But man, like, it's like you examine every cut that you ever made, and Dick talked about this on one of the episodes recently, where he's examining that everything cut from various episodes felt like or cut from his book, I think he was talking about, felt like a knife, even though he knew it was the right cut. And sometimes we know that it's the right thing, but man, you think, what if I would have just had that one more authority that was just tangentially related? Might that have tipped the scale? So the next question is from Snake Jerusalem. He asks, can Maddox sue Dick over releasing the unmaddoxed version of the episodes? So what they're talking about is that Dick has several unedited copies of The Biggest Problem. Can he release those? And if he does, can Maddox sue him for doing that?
Here is
without giving any legal advice
to everyone who ever asked me, can I be sued for doing this? The answer is yes.
Yep.
Someone can sue you for literally everything you've been doing. Will he be successful? I would doubt it. But if you were to ask me about other things Maddox is sued about, I would say be unsuccessful. So, I mean, whether you can sue someone for something is... Of course you can. If you've got money to pay the filing fee, you can sue somebody for something.
So then the answer is no.
Yeah. That would be off the record answer. It would be a dumb idea.
Yeah. So yeah, the lawyer answer is, yeah, you can be sued for anything based on the resources of your opposition. But the short answer is, like, and correct me if I'm wrong on this, but as co-owners, I think we kind of talked about this earlier, but I want to clarify. As co-owners without an operating agreement of this general partnership, the presumption is that either of them can act in full authority as long as the partnership's interest is the best interest of the decision, and more particularly, not a wasteful decision. So they're not going out there and deteriorating the value of the brand. Even if they're not improving the brand, they can probably make decisions with full autonomy, either party, so long as they split any sort of proceeds that come to them.
Right. I mean, absent breaching some fiduciary duty, they're good. Right.
Okay, so the next question. So Hatsnaj says, thanks for bringing Scalia back. No problem. I just needed room for him. Sadly, we cannot resurrect him from the dead to...
Sadly. Very sadly.
beguile us with hilarious opinions. Like I said, even when I disagree with Scalia, his opinions are good to read.
Exactly. 100%. Yeah.
So the biggest dickhead asks, as a small town law, what is the furthest you've ever traveled for a case? For me, it's about 3 hours, a 3-hour drive for a case, it's a nightmare. But thankfully, I have family that are within a couple hours, that are usually within an hour of wherever I need to be, so I can stay with them if I have to. What about for you?
Oh, it's deceptive because Florida's a big state. Right. And everything, a lot of the regulatory stuff we does happens in Tallahassee, which is a 5-hour drive. And I mean, that's a regular occurrence. So it's about 5 hours I've driven.
That's a long case.
God, tell me about it. And it's all the time. And yeah, we're all over the state all the time. I feel bad for partners sometimes. They're in Miami, which is like crazy far south, and then the next day they're in Tallahassee, which is from Miami. It's an 8-hour. They're all over the place. It's
sweet when you get that per diem from the client and those billable travel.
Oh, the hourly rate. When you get paid, it's all worth it. Yeah. As long as you get the hourlies, you're good.
So Andrew Gluck says,
that's the job.
Right. In case you weren't keeping track, Maddox is down 24 subs. Ooh, that's brutal. Just during this stream.
I like to think that half of those are mine.
So Greedev asks, what is the most indefensible case you've ever defended? And I'll let you answer first on this one, and then I will answer second because as a criminal lawyer, I think mine might horrify and offend people more, but I bet yours is more interesting.
No, mine aren't interesting. I've had people present me with contracts the night before trial, and I am amazingly happy that they finally. And then people point out that the company didn't exist at the address at the time, and there's nothing more embarrassing than basically presenting perjury to the court. But I don't have a lot of crazy issues. You may beat me on this.
I beat a lot of people on this because I had a case that okay, so brief background on me is when I was entering into law school, I thought I would be a prosecutor or I thought I'd be a corporate attorney. I did not plan on being a defense attorney, but going through law school and then getting out of law school and having to work, you kind of just deal with what you get. And in my town, that involved criminal defense. And then I found out that I really, really enjoyed it. And I really stinking hate the government so much that defending people against them felt great. But, but I had a case where a man was accused of impregnating his 13-year-old daughter. And I did not end up taking this.
It happens.
Not normally, not to normal people. No, I had to. I did not end up taking this case in as a full defense issue. However, I did. And there's a lot of reasons for that, and none of them. I don't want to point out that like I had some moral or ethical obligation or objection to defending this person. I was actually on board to defend them. There were just some practical logistical issues with me doing it, but I ended up doing the plea hearing, the guilty plea hearing, and it was probably the darkest day of my recent life, we'll say, because I had to sit there with him while a man admitted to doing like the most horrible thing I can think of as a father, and I'm sure you as a father can attest to just like how dark the concept even is, and to have him have to sit on the stand and tell the judge what he did was like beyond anything. And I want to point out, like, this was the case that taught me the most about the fact that the narrative that you get from whatever news source, from whatever person you're hearing, is only a part of the story. And it's 100%. It's really easy to demonize this guy as a monster. And in a lot of ways he is, but I can tell you that the conversations I had with this guy, I can't tell you any details about him, obviously, but the conversations I had with this guy, even an hour before that hearing, were the most human conversations I've ever had, and they were completely detached from this. And without knowing what had happened, this guy was completely normal, affable. We had great conversations. And then even after the hearing, like as this guy is sentenced to 12 years in prison after pleading guilty, I got hugs from him and his family. And it was like, well, we're going to go play some video games. And it went from like human to super dark to human in the blink of an eye. And it's the ability of the human mind to deal with that was shocking to me. So that's the worst case. It was absolutely indefensible because we had genetic testing on the dad and on the child that matched up with like 99.9999999. I can't even count the nines % accuracy. And they had misread the test at first, and so they thought they had a case. But when I had to tell his mom that the genetic testing was basically conclusive, that was a hard day. That was a hard day.
Right.
So but everybody deserves a defense, and in that guy's case, we got him to a guilty plea that would get him help, right? That would get him prison time because he needed it, frankly, needed the prison time, needed help, and hope, but it wouldn't put him away until he's dead. And hopefully, I have lots of hope because I talked to that guy and he was outside of that event, was a reasonable human being, and I hope that he gets the help he needs, and the hope is that he'll be reintegrated with his family at some point in some safe way.
I think I will tell you, I think the thing that news and media in general just fails to give you the full story.
Yeah,
they're horrible people. I mean, and you probably more than I do, but I deal with people who aren't good people, and they're just, objectively not good people. But they're not the worst, and they have their redeeming qualities, and there's nothing more freeing, especially, I think that's what I like about my job, is especially when you've lost, but you get to stand there and you get to argue, you get to say, hey, look, judge, this is what I have, and you're going to lose the whole time. Like you're standing there, you're like, the most futile thing I've ever done. But just to stand there against the entire government, like coming down on your client, is
right.
It's a good feeling, and I think it's an important job. And if we let the masses come down on people against what they feel is right at the time, it's not justice. And
right,
I don't know,
man. I'm not gonna bring it up on stream too much here, but there's a guy in Minnesota who I think you'd love his book. His name is Howard. It's either Howard or Harold, and that's embarrassing that I can't remember. But I think it's Howard Root, and he started Vascular Systems Incorporated. And if you haven't had a chance, since you deal with medical and regulatory issues, like he put a book out. Basically, he was indicted by the federal government as CEO of VSI Incorporated for something that wasn't a crime. And so he spent 18 years under federal felony indictment for basically making false claims not approved by the FDA, even though they didn't have to be approved by the FDA. And their company had a policy against making them. And it was one rogue salesman who made the policy or who made the statements. And even if he had, it was legal. But
right.
This guy was just railroaded, and it cost something like $20 million to defend. And he ended up selling the company. But I'll send you his info because I think his book would make you smile.
Please do. I mean, it's sad to see, what we do, and especially on your end, but even on my end, you see people who are right and they've done nothing wrong, but they're faced with the entire federal government coming against them, or even the state government coming against them, and who can defend against that?
Right.
And they make these plea deals that you're in a position where it's, well, I need to feed my family, so let's plea out, and what are they supposed to do?
Yeah,
it's
scary
to me.
Lucky for this guy, he was CEO of a multi-billion-dollar company, so he was able to defend it. But it was crazy. Okay, so I've got another question. What are your thoughts on crappy children's artwork having possible unlicensed photos in a published book?
I have lots of thoughts, but yeah, I'll reserve my thoughts on that for
Sounds
now.
Good.
I'll take those thoughts under advisement because I would not want to be a person who published works without someone's authority. That said, it's been a while. I don't know how much he's made off that book, so I don't know what the damages would be.
I would wager it's little. I heard it was a tank.
Exactly. if this were closer to publishing date, there's statutory damages, but
yeah,
at this point, I wouldn't want to be that person, but
yeah, it depends. I mean, if maybe we're wrong and he made good money on an advance or something like that based on the other book, and then he'd have some real.
I don't know if he made good money on it, and Landau's who he decided to hire. He's got other issues too.
Okay, I'm supposed to ask you, and again, feel free to not answer this, but I'm supposed to ask you what hand you self-service with.
My dominant hand. Who does? Dick's right about a lot of stuff, but
that's a weird
100% wrong.
That's a weird one.
Your dominant hand is the appropriate hand, and that's just a fact.
All right, so then this is a different question. If Maddox has his SoundCloud monetized, is Dick entitled to a cut of any money from people who listen to the Biggest Problem in the Universe episodes or any clip songs on the feed like the Maddox Lost song? And my thoughts, and feel free to correct me on this, but is yes, Dick is entitled to the money, but the cost of enforcement could bar him from recovering that money. But you go ahead and...
Yeah. I mean, cost of enforcement is cost of enforcement. I mean, that's a separate issue. I think there's a very good argument that any money that has been monetized by either party based off of the joint venture is half either parties. And
right.
And at this point, I would think that's a conceded argument. Certainly the Trademark Trial and Appeal Boards agreed with me,
right?
Which is I don't know, that's nice to have. So I would think it's definitely half Dick's.
So then, as a follow-up question, this is what I was curious about, and this touches on the lawsuit. So feel free to not answer if you think it's in dangerous territory, but. There's an allegation made by me that Maddox may have stolen the feed, and that if he had, I guess Dick initially alleged that Maddox stole the RSS feed for the Biggest Problem in the Universe and switched it to the Best Debate in the Universe. And if he had done that, what would be the damage as far as, let's say he made proceeds from the advertising dollars on the Best Debate in the Universe? To me, this gets into a weird legal territory where it seems like for a period of time following the initial taking of the feed, he would owe Dick some money for those listens, but then it would be a diminishing return as time went on. But I don't know. That's such a weird, I don't know what even authority to look for that. So if you have any thoughts, let me know.
And this isn't going to be a popular answer, but how speculative is that? And then turn that around. I mean, Dick has the Biggest Problem .thedickshow.com. How much money is he from that? And I think the answer to both is no one knows. I think it was a shitty thing to do. I think it was not the proper thing to do. I don't think he had the right to do it. I think in sort of, an equitable situation, you can say, no, you can't do it. There's some sort of injunctive relief. In a legal, how much damages do you have? I think you've got a hard time proving damages to something that speculative. What damages did you get? And it's probably not the popular answer, because you want to say Maddox, but
no, it's fine.
And I do. I say it all the time. But those are things that were wrong, and those are things that need to be remedied. But what's the damages? I think they're hard to speculate on.
Yeah, to me, that argument belongs in the lawsuit if the dismissals don't go through, then in challenging specific aspects of, well, Maddox claims he lost $7,200 per month from the Harry subscription. And it's like, okay, that's either based on a falsehood, or it's based on the inflated feed numbers and he's conflating biggest problem sponsorship with best debate sponsorship or something like that. But to me, outside of that, there's just like, even if there are damages, like like you said, how do you prove them? Because people are at that point, they're tuning into best debate. Presumably advertisers are advertising best debate, not biggest problem. And whether or not he stole the feed becomes less and less of an issue the more things we add into it. But
yeah, I mean, and that's something, it's fun to speculate. It's fun to talk about. It's fun to discuss on Reddit. But I mean, it's not something you want to be dealing with in front of a judge, because there's no real basis to stand there and say, oh, well, I lost X number because of this. And I wouldn't want to be on Maddox's side arguing I lost X number of readers because of feed. And I think Dick suffers from that too.
Sure. Okay, so next question, and I'm gonna interject a quick question going into this, but have you accepted Jesus Christ as your Lord and Savior?
Oh, I grew up crazy Southern Baptist. Of course I have.
Okay, so Matthew Reifler asks, what is your favorite Bible passage?
Something about man, Jesus wept. I don't know.
There you go.
What am I supposed to...
Best verse in the Bible. I'm with you. I'm with you. No, I actually,
short, sweet.
Like going Bible nerd on that. I read this or heard, I can't even remember if I read or listened to this theological exposition on Jesus wept, and just how like devastating it was to see the creator of humanity, who apparently at the garden, at the time of creation, had created people to never die, to be basically immortal,
right?
To be in a graveyard, witnessing the result of the brokenness, and that the creator of humanity, seeing his creation, who should have never died, being in a land of death, was actually devastating, and that was pretty moving. So,
and to know that they were about to execute him, I mean, right. That's a big deal. Yeah. I'm no theologian, and I don't take any sort of advice as to your immortal soul by me. Your mortal soul,
get it from
I'll
YouTube,
take that.
Definitely get it from YouTube. Okay, someone said with the Legoland question, we made the wife happy, so that's good. Do you feel guilty beating a literal orangutan in court?
Never. I will tell you, there's something that feels a little bit better when you have a good opposition, but there's a win is a win. It's the best feeling. There's nothing better than winning.
Okay, so the next question is, are you keen on doing a lawyer meetup in New York after the aftermath? And I would say in New York or Los Angeles. And this is something I'm hoping for, and I'm hoping we can align all of the lawyers involved into doing this, that when the lawsuit is ended, we can have just a law rager and get everybody together. Are you up for that?
I am, but who would want to listen to anyone other than... I mean, why have anyone else? It's God, he's amazing. I am jealous of what he's done. I'm in, but
the audio
when you can have Greenberger.
The audio cut out, but yeah, you said Greenberger there. I could read the lips and your mind. But yeah, so yeah, and I mean he's on my bucket list. Literally, meeting Greenberger and buying that guy a beer or something is on my bucket list.
Right.
Of things to do. So I'm hoping that gets to happen. Dick, if you're watching, we want to meet Greenberger, and you have to make that happen in some way. But in all honesty, like I hope to be able to interview Greenberger. I hope to be able to interview Matz. I have the longest shot hopes of being able to interview Munoz, because I bet that guy is hilarious. Even if it's because he's the straightest lace person on the planet. And
well, you have to be. Even if I were smart enough to come up with something Greenberger, which I'm not, by the way. Like I'm not smart enough to do that. I don't have the balls to do what he did. Like that is impressive.
I would have never thought of it. Never would have thought of it.
No.
Like my ballsiest thing in court was I objected to a line of questioning during examination from the prosecution, and the judge says, on what grounds? And my answer was, I mean, are we serious? And it was sustained. So but
then you win.
It was the dumbest thing I've ever seen. The judge had berated the person, the other attorney, several times for like asking the same question over and over, the same line of question that I had objected to multiple times and had been sustained. And then it was objection. What grounds? I mean, are we serious? The same grounds. But yeah, going to the Easter eggs in his thing was just monstrously funny.
Yeah.
So Eddie Jefferson says, I love Nick Gers. And then I got to get to these super chats real quick before I lose them.
Okay.
Donate to patreon.com/Asterios. Maybe he'll help you meet Greenberger. And that's a good thing to do, by the way, if anyone out there is watching.
Agreed.
Asterios needs all the help he can get. And because guys like Burch and guys like me we're expensive because we spent a lot of time and a lot of money to go to law school to learn this stuff. And we think very highly of ourselves. But no.
You joke, but it's people lose all the time because they can't afford representation.
Yep.
And Asterios is in a very bad situation where he's stuck with these, an amazing attorney, which I'm sure is not cheap.
Right.
To represent him against frivolous claims.
Yep, absolutely. And speaking personally, and I'm betting you're in a similar boat given the age of your family, but I gave up multiple nights a week for 3.5 years to finish law school. Spent multiple nights 3.5 years away from my kids, and that's a huge thing. Lawyers sacrifice a lot of time. That's why we cost so much. Also because when you have us, your chances of winning increase dramatically. But right. Greenberger is clearly a competent guy. He's also the funniest funniest lawyer I may have ever met, and I'm hoping that you guys will help Asterios pay for him. Okay.
The only thing I ever asked for me being on here, if you get Greenberger on the station, I would like to just say hi. He's impressive.
We'll figure that out. We'll figure that out. Like I said, I'm hoping that we can have a lawyer rager when all of this is concluded, but we'll see. Okay, so then the next question, Spinston asks, live stream from Legoland. We'll see what happens. It really depends on Legoland's internet. Some hotels have good internet, some don't. Gabriel Tripp says, question for both of you. In your opinions, does copyright and trademark law need reform to protect the common man? I'll let you lead on that.
I will tell you, my personal thoughts are that intellectual property in general, and things have been going in the right direction, but they've got too much of a pull, of a sway over just general judges, anyone in general, and they. I don't know how to put this, but they definitely need reform, because otherwise, especially with the way things have changed with the internet, people have been, I don't know, put into weird positions, put into positions where they're silenced when they shouldn't have been. So agreed. There's a lot of room for reform.
So I will agree with you, and I think, and this is a cheap answer, but I think the entire legal system needs reform. One, it's way too expensive. I mean, like I just talked about why we charge so much. Part of that is just what we have to go through to get to where we are and being able to provide competent counsel for people. But it's still too expensive for people to deal with real issues that they have. Because not every issue is $1 million issue. You know, most people are dealing with stuff that's like, you know, $3,000 from a renter who damaged their place and they're leaving or something like that. And people shouldn't have to pay $8,000 to get maybe a $1,500 settlement from a deadbeat. Like that's
right.
That's the kind of issues that the legal profession has to figure out. And hold on, the bit rate on the stream is really suffering. Okay, it's back.
No.
So the whole system needs to be fixed. But I have a mild assignment for you, and I say assignment in the complete tongue-in-cheek way. If you're interested, there's Alex Jones is being sued. And I'm not an Alex Jones fan or supporter in any sort of way, other than I find him kind of funny from time to time. But he made a poster, and in that poster he has Pepe the Frog on there, and he's been sued by Matt Fury, the creator of Pepe the Frog. And I think, man, I read that complaint, and all I could think was that Matt Fury spent the entire time making a fair use argument for Alex Jones.
100%. But that's, and I will tell you, the scary thing is if you're an attorney, the judges who are going to hear this have been attorneys, and none of them have gone through any sort of intellectual property class. None of them know intellectual property law, and it is used, it's abused, and people are able to take it and silence speech based off of nothing more than, oh, it's a copyright claim, it's a trademark claim, and it's hard to stand up for people like Alex Jones. It's hard to stand up for a lot of these people that are just reprehensible in general, but you have to, because if you don't, who's next? And I mean, you see who's next. I mean, Dick's being sued for $20 million, $400 million. I have no how you calculate that, but
I don't think Landau knows how you calculate that.
No one knows that. But it's based off of this idea that there's some sort of law that your speech isn't protected. And it's wrong, and you have to stand up for it for everyone, whether it's Alex Jones, whether it's some hyper liberal person. It doesn't matter. It's a speech needs to be protected at every step.
I'm trying to get a wiki quote of me, and it's defend everything or defend anything or lose everything.
100%.
Because to me, like that's what it's starting to come down to, is we literally have to defend. I mean, we have to defend, as far as speech goes, the worst of the worst speech. It has to be defended. For law nerds out there, Brandenburg versus Ohio is the leading case on protests and incitement, and you have to defend the KKK. You have to defend the people saying the most horrifying things, because all of our rights to speak depend on it. And if you don't believe me, look at the UK and look at what they're doing to guys like Count Dankula, who made a joke, and they're putting they're charging them with crimes that potentially carry like 6 months in prison for a joke.
And you look at Brandon, you look at a lot of the street speech cases, and it's the ACLU, which is, I mean, for all their faults, for the most part, up until fairly recently, they were there for free speech, and it's important. And recently, that's the scary thing is, the ACLU's not there, and there are people who are willing to give up very, very essential rights because it's not convenient, it's not politically convenient.
I think the difference between being a conservative and being a conservative who has graduated law school is you go from not appreciating the ACLU to appreciating everything they've ever done.
Right. They've done good stuff. I have time hating, but I do recently. But man, they've done some good things.
Yep.
And I'm on their side for stuff when they're ready to stand on their principles. Yep. But they're not always ready to stick to their principles when they're worried about donors.
Them and the Supreme Court are withdrawing on a couple issues lately that I would really prefer that they don't. So,
right.
Alan Foster says, "Isn't it hilarious that Burch somehow has more hair than Maddox?"
Listen, the Maddox has, but he has more hair than I do. I do not have a lot of hair.
No way, he lost on that one too. Samuel Olivero says, "Thanks for answering in the stream." That was like 20 minutes ago. We answered his question. Hatbuckles says, "Did you know that the USS Maddox was the ship that exaggerated attacks against it in the Gulf of Tonkin incident that wrongfully kicked off the Vietnam War?" Really makes you think.
I did not know that. I'll stand by it though. I like it.
Someone asked if I can use, or if you, maybe either of us, can use the name Best Trademark Lawyer in the Universe, and I think we've established that you are, just by winning this case, the Best Trademark Lawyer in the Universe. I have no problems with it.
No, it's a joint effort. I'm good with. We'll share that.
And in my opinion, Maddox had a failed argument about owning, quote, in the universe, ... in the universe. So we'll say. That was the dumbest thing from his entire. I was like, that doesn't matter.
No, but I will tell you, from an attorney standpoint, like that's the one that got me. I'm like, that's a real legal argument, and so you have to do research, and I'm like, that's not right. Like that's not a thing, but it's not.
You can't just let it go.
Right. It's not the stupidity that the rest of his arguments were. Right. And then you look it up, and of course it's like, oh, yeah, I'm good. But that was the better of his arguments.
Yep.
Wrong, but
better. And that's where we live. So Tillip says, Florida might be the best place to be a defense attorney. Finding clients is as easy as looking in the newspaper. Florida man assaults man with gator over Gatorade. And
hey,
true,
listen,
your state has some characters, we'll say.
I will tell you, our state has the, look it up, we have best public records, open government thing. So all of our stupidity is open for the world, but
the rest of us just hide.
Exactly. Also, we got a lot of crazy people. I've related to most of them.
So Tess says, down with the man, and then she says, I love you, buddy, but I'm starting to cry. That was during my depressing story about a horrific crime. Maddox is down 27 subs. Rekieta laws.
At least 3/4 of those are because I like to think.
Yeah, absolutely. And Zealous Enui says, Rekieta law represented Digibro. Confirmed. No, I've not represented Digibro. But, Dick's right, like as we'll say eccentric as Digibro's interests may be, guys like Digibro need a defense. And I will say that obscenity is not, does not, or I guess child pornography specifically in the statute does not include depictions of child pornography that do not involve actual children. So, he's technically in the legal clear, although it is a weird position morally and ethically.
You take that position, buddy. That's all you.
Sometimes you got to defend what you don't agree with. Zircon says, could Dick release edited Biggest Problem in the Universe episodes with Mad Cucks replacing Maddox's voice? What do you think about that? I think he probably could, especially. I mean, I think it's interesting because if he acts in the interest of the mark and does something like that, and then sends half the proceeds to Maddox, I think absolutely. And
Oh,
maybe
100. If he's sending half the proceeds, 100%. I mean,
yeah,
to the extent he does it out of the goodness of his heart, I mean, when
right,
there's no proceeds. But yeah, he's. There are arguments. He owns the mark. I think at this point, it's undisputed that he owns, half the joint venture, so he can do what he wants with it.
right.
I mean, to the extent there's other fair use arguments, but yeah, he can do what he wants. If there's a profit issue, that's a different. But he can do what he wants with the episodes.
So I want to get to let's see, a couple super chats that I've been neglecting. Not intentionally. We've just been having good conversation, so I didn't want to break that up. Great Dolomite says, this stream is entertaining AF. Thank you, gentlemen. Well, thank you, buddy. I really appreciate it. I'm glad you're enjoying this. And Javier Miedo just chatted, can someone give me a summary of the trademark suit? Would you like to summarize the whole thing from your perspective? Because I think I've given... real quick, Javier Miedo also said Landui charges astronomically for competences. But would you like to summarize the suit? Because, I mean, I've given my opinions on it, but if you have your... if you have your sort of perspective on it, I think people might like to really hear that.
Here's my 10,000 feet perspective. Maddox, he filed for registration saying that he's owned the mark, the biggest problem in the universe, and he's owned it since. And I'm sorry, it's been a long night, but forever,
right,
since the beginning of
time. We can just go back to the beginning of time.
Thank you. And at some point, he realized he couldn't. And so he said, hey, I'm going to own it from now to the future. And he was wrong. There's no question he was wrong. He was trying to take from Dick things that were not his. And he was wrong. And he had no ability to contest that. We put forward, I don't know, a motion for summary judgment is a difficult win. And we put forward our case to challenge his affirmative defenses, to challenge his, just basically his denials. And he had nothing at all to say against it. And at the end of the day, the point is, he didn't own it. It was a joint venture between the two. He doesn't own it. It's something that's jointly owned between Dick and Maddox, and he never had a chance. There was nothing from the beginning.
Yep.
When I deal with clients, I worry 100% that they're not telling me what's going on, and you get half of the case. And so at the beginning, I was worried, what's Maddox going to show that Dick hasn't shown me? And the answer was nothing. And nothing. It was the most depressing climax in the world when I got responses to Discovery. Because there was nothing. I was like, even my best clients, it's not that they're intentionally lying. It's that, they see things through their lens. And so I expected something. I get nothing. There's nothing that Maddox had in his defense that defeated everything Dick has said. Nothing that Dick has said throughout this entire episode, throughout, step outside of the trademark lawsuit, everything relevant to that, he has nothing. And it's sad, it's depressing, and it's kind of weird that someone take on the position they've taken, given the lack of evidence in their defense. It's crazy to me. Unfortunately, some of it's still confidential until people make their decisions. But I will tell you, there's nothing in his defense that supports anything he said.
No, and let me inside baseball a couple things you said for the audience. You mentioned that summary judgment motions are hard to win, and if you guys don't know, summary judgment motions are made in 99.9% of civil litigation. They're always made because I mentioned this before, motions to dismiss and then summary judgment motions, if you win them, you win. So everybody makes them, but they're not easy to win because they mean that on a motion for summary judgment, you take what the other party said in the light most favorable to them, and you say, we agree with everything they said in the most favorable way, and we still win. When that happens, that means that the other party had literally nothing to stand on. And that's I mean, they lost based on their failure to respond in part, but from the rule, the court the board doesn't have to just decide that they had a failure to respond and that's an automatic loss. They can actually consider the motion that's presented and they can say, you know what, they didn't respond, but they still have a material fact in dispute. And if that material fact is in dispute, then they have to keep going. So that's the first thing. Oh, go ahead.
Oh, so I could have spent less than half an hour of billable hours to come up with a material issue in dispute, and they still had nothing.
Right. Absolutely. which is baffling. But then the other thing you mentioned is that as lawyers, we deal with clients who don't tell us the truth, and it's often not intentional for them. They're not lying to us, but you mentioned earlier, people are the heroes of their own story. And you have to remember that the people who are talking to us are at some of the lowest points in their life, either economically speaking, everything rides on what we're doing. In my case, people's life, if they're charged with a felony, I mean, they're going to go to jail. They're going to have this felony loom over them for the next decade to 2 decades to come. That hangs in the balance. So they don't tell us everything. And the fact that when Maddox responded to the interrogatories and there was nothing, that's insane. So yeah. So there's just kind of some inside lawyering on that. Let me burn through a couple of these comments, and then I think we should wrap up the stream because we're coming up on 3 hours, and you and I are both tipping the scales of inebriation. I think, at least speaking for myself.
I've never been inebriated. I've tried. I keep drinking. Never been inebriated.
Real quick, Tess says, thank you so much for joining us, and she wants to pick your brain on IP stuff later. She's very interested in IP law. she's a law school student. So if you'd be open to that, I'm sure she'd love to talk to you.
Of course. I will tell you, I'm more of a lurker. I definitely know what's going on the Facebook page, on the Reddit page. I don't post very often because it's interesting, but
sure.
If she has questions, ask them. I'll answer them.
Absolutely. Tillip says, my favorite Bible verse is the one where all spirits were dropped from 747s into volcanoes, thus causes bad emotions. I have no idea what
was that saying. Joe versus the volcano?
Yeah, that was a bad Tom Hanks movie.
Is that a Mormon? I
Wild Matsu says, for Stephen, a win is a win. Isn't there a sense of anticlimax when you win by default by this? And I'll let you say it, but I'm pretty sure the answer is no.
No, this is a win by default. I will tell you, everyone, if you want to cite to it, it sucks when you get these short answers. But when you're looking at what are the appealable issues, it feels so good. Those very short, you win, the other side concedes, it's the best win.
Remember that the opponent just paid hundreds to thousands of dollars for them to lose. So winning is never not refreshing. There is no letdown win. Winning is winning in our sport, so to speak. So Fuzz Got Games says, are there any great historical lawyers? Is there the Beatles of law? And I would say Cardozo and Posner are the Beatles of law as far as
Posner's gone crazy.
Well, lately he has, but he has.
I've seen him. I'm not against it. I like, but he's a little crazy lately.
I think Cardozo wins though, going from like hilariously effective litigator to judge with like flourishy Scalia-esque opinions. Like that's running the gambit of the law superstar.
I like Cardozo. Yeah. I like Thomas. I will tell you, I like the idea of people. I like watching the news talk about, he doesn't talk. He does, knowing that oral arguments are completely arbitrary.
Right.
Like he's got teams of law clerks working for him, as does every other Supreme Court justice. I like Thomas. He's my hero.
And the funny thing is, Thomas has built this air where when he asks a question, it's news. Like,
right?
How do you do that? Where like when a justice opens his mouth, it matters. Like that's in a way as important as someone like a Scalia, who when he pens an opinion, it matters. Because of how he pens it. But to me, Thomas on the Second Amendment issue lately, when they refused to hear California's case on the 10-day ban, and Thomas has a dissenting opinion that's like a paragraph, and it basically says
it's an important dissension, though.
Right, and he says the Second Amendment is disfavored in this court, and it's like, whoa, I mean that is an indictment of the Supreme Court and a fundamental right and how they're treating it. And that's like, he has built up his ability to do that in a way that no other justice can muster. So
no, I think that's, going back to the current case, I'm no Greenberger, but in my mind, when I say I disagree or that's incorrect, that's a big deal as an attorney. Like, you don't just say that. Like, that's for, and when you hear, Greenberger's funny to read, great. But when you hear a Supreme Court justice say something like that as an attorney, I don't think the rest of the populace realizes, given all the things that the news says and what they're used to hearing, how big a deal that is. It's a big deal to hear a Supreme Court justice say something like what he says. It's
right. And to give you some perspective on this, if you ask con law professors who you should read, what you should study to learn con law, they will partisanly say, read the Supreme Court justices. They're the 9 most accomplished constitutional lawyers on the planet at any given time. And so even if you have some, like, I personally disagree with a lot of what Sonia Sotomayor or Elena Kagan would say, because I lean to the right, obviously. Even when you have one of them say, as a matter of law, this attorney or even this other justice is wrong, like, that carries a weight to it where you have someone who is the most researched person with the most resources on the issue on the planet saying something, and that's pretty impactful.
Right.
But
and they're very understated, but as an attorney, it makes a big, say something.
It's where you never want to be. You never want to be in front of the Supreme Court and have them say you're incorrect on the law. It's like, oh, good. Do you guys ban guns if I'm only using it to kill myself?
Right. It's over.
Okay, so hypothetically, fake child porn, someone pretending to be a minor, trademark lawsuit. Would the owner of the footage be able to claim ownership and charge for viewership from the court? It's a weird question. It's a weird question because child porn is factually dependent on the actual age of the actors involved. So like if it's a 20-year-old who looks 12, I mean, it's technically legal.
It's not as simple as you see. Right. There are lots of rules, and I don't want to discuss on Paul how I feel, but from a First Amendment standpoint, I think a lot of our child pornography laws are wrong.
Yeah, and it's a really tough issue.
I don't want to be the guy defending, but I do think they're wrong.
Yeah, and what was interesting to me is in the definition of obscenity. The definition of obscenity from the Supreme Court is technically something that arouses the prurient interest, which is the explicitly sexual interest in the viewer. So for them to even label child porn as obscenity is them saying that child porn is irresistibly arousing to the audience, which is disturbing in its own right to me.
Very.
Okay, real quick. On Alex Jones, what about the other lawsuit where a female writer claimed hostile work environment? I found the accusations hilarious. I haven't read it yet. I don't know if you've read that. Is it true?
No, I haven't.
Is it true Florida doesn't have parole of any kind? That doesn't seem correct, but maybe...
I am not a criminal attorney, but I know that's not correct.
Let's see. All right, I think I'm going to wrap it up here. We have like 4 questions left. Thank goodness they've slowed down because I really have to go to the bathroom. Do you have a copy of Clay's work schedule? That's the only way I can think that you consistently do these while I'm working. Yeah, Clay, I called the pizza delivery place, and they told me when to do streams. And does it hurt that Burch outdrank me tonight? No, not at all. Not at all.
I will outdrink anyone. That's a very...
Contrary to Lagavulin's assessment of me, I don't actually drink that much, and outside of these streams, I rarely drink. So, no, I am an admitted lightweight drinker. I am not a proficient drinker at all, and I hope to exploit that at some time in the near future. When we get to have a giant party with all the lawyers, I will be happily drunk under the table by any of them. Wonder what's more pathetic, Landwee's professors passing him or Maddox's trademark suit. That's pretty brutal. I will say that law school and the bar are not good indicators of who will be a good attorney, and certainly not who will be good at specific aspects of being an attorney. I was kind of theory crafting earlier. Landau is going through an MBA right now out in New York, and I have an idea that maybe he's a very competent business attorney as far as the advice and drafting of contract side, although with his grammatical errors, I wonder. But it's possible that he has some sort of expertise and litigation is just not his strong suit, or maybe he is fantastic at oral argument, and that would be interesting, but I doubt it.
Yeah, I not specific, but it's amazing what attorneys get by with. I mean, there are certain who are good at writing, there are certain that are good at oral argument. He doesn't seem, I don't know, but it's an interesting profession, and being able to pass the bar has nothing.
Not a thing. Even though I passed it on my first try. Suck it. No.
Well, who doesn't? I did too.
But no, they're
all those second try losers.
I mean, there are literally third try bar attorneys who come out and destroy people in court. Like, the bar is this weird relic of legal practice, and do not be surprised if the bar is outmoded in the next couple years, where you've got basically passage of law school within your state licenses you to practice in that state, and you'll only take a bar if you want to practice outside, because that's coming. That's coming. The bar is a very bad barometer of who will make a good attorney. So biggest dickhead says this stream makes me think spite is a very important part of being a law. I think that's true.
100%.
Drums or flats. I don't even know what that means at this point. The most legal form of martial art is obviously salat. only because there's a Salat champion who had both of his arms broken and defeated his opponent by jump kicking him into submission. And
I don't know what Salat is, but I agree.
It involves a lot of kicks. That's all I know. Actually, have you seen the movie The Raid?
No.
Okay.
No.
Go. I don't care how late it is. Go watch The Raid sometime
I
really
have
soon.
nothing else to do.
It's
Sounds
a great,
good.
great movie, and they use Salat as the primary basis of martial arts for The Raid. But it's a good flick, and The Raid 2 is also awesome. But finally, Clay says, make Tess and Andrew Gluck and Captain Jerkass drink. Okay, you guys drink. But that's the end of it. Somehow we made it through all the questions. Hey, man, I really, really, really appreciate you being on. And I was going to ask you, I promised to ask you a question that would be binding. Oh, yeah. So as part of this show, I get lots of legal questions, and I would like to ask if you would be willing, where if I run into trademark issues, if I could refer you clients. And
No, that's I mean, I prefer not to have clients.
Right. Who wants to have marketing?
Yeah. No.
So
I appreciate you having me on. I'm very grateful. This is it's an amazing show.
Well, thanks, buddy. I really appreciate it. I had no plans on doing. I actually had a plan to do a podcast that would probably be far less interesting than this, but no, the time presented itself, and I got drunk enough to try something silly, and here we go. So I really am glad that you are a fan of the show, and I hope to be able to drag some other lawyers onto here in the future. And yeah, if I get Greenberger on, I'll make sure and find a way to get you involved in that, because you know, I think any lawyer who reads his motions would want to buy him a drink.
I would. I'm at every step of it's impressive.
Yep.
So
yep. All right, man. Well, I'm gonna blank out our chat or the video here, and we're gonna end it in probably about 45 seconds to a minute. So I really appreciate you being on, and hopefully, you know, if I run into any other trademark stuff, I'd be thrilled if you would offer some commentary on it. But I'll give you a little prep time for it so you can gather thoughts. But
sounds good.
I'd love
Thank
to be
you so
able
much.
to. Yeah, I'd love to be able to have part of the show be me interviewing other people with more expertise and getting their opinions as well. So,
well, I loved it. Thank you so much.
Thanks, man. I'll talk to you soon. Have a good night.
You too. Bye.
Bye.